ជាដើមគឺថានៅពេលអនាគតនឹងអាចមានការយកដំណើរការទាំងមូលនៃការកាត់ក្តីនេះយកទៅប្រហាត់ប្រហែងនៅក្នុងចំណុចផ្សេងៗការកាត់ក្តីទៅលើអ្នកទទួលខុសត្រូវទោះថាគាត់ឋានៈធំប៉ុណ្ណាក៏ដោយដែលគាត់ធ្វើប្រព្រឹត្តបទឧក្រិដ្ឋធំទាំងអស់នោះគឺពួកគាត់នឹងអាចដឹងថាអំពើរបស់គាត់នឹងថ្ងៃណាមួយនឹងត្រូវបានយកមកកាត់ក្តី
ក្នុងរយៈពេលដំណើរការសវនាការនៃសំណុំរឿង 002/02 ចាប់តាំងពីឆ្នាំ 2015 ដល់ឆ្នាំ 2017 មានដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន 63 នាក់សាក្សីចំនួន 114 នាក់បានឡើងផ្ដល់សក្ខីកម្មនៅចំពោះមុខអង្គជំនុំជម្រះសាលាដំបងជាសរុបមកមានដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន 3865 នាក់ត្រូវបានអនុញ្ញាតឲ្យចូលរួមនៅក្នុងសំណុំរឿងនេះគម្រោងសំណងជាសាធារណៈត្រូវបានបញ្ចប់ក្នុងនាមពួកគាត់ការចូលរួមរបស់ដើមបណ្ដឹងរដ្ឋប្រវេណីមានសារៈសំខាន់ណាស់ដោយដែលលោកមេធាវីនីចន្ទឌីធ្លាប់ធ្វើការយ៉ាងជិតស្និទ្ធជាមួយដើមបណ្ដឹងរដ្ឋប្រវេណីកាលពីពេលមុនលោកមានប្រសាសន៍ប្រាប់កម្មវិធីរបស់យើង
សវនាការនេះគឺធ្វើឲ្យទី1គឺថាធ្វើឲ្យប្រជាពលរដ្ឋបានចូលរួមនៅក្នុងនីតិវិធីនៃតុលាការផងហើយនឹងចូលរួមនៅក្នុងវេទិកាផ្សេងផងអញ្ចឹងទេតាមដែលខ្ញុំបានឃើញគឺថាគាត់បានបញ្ចេញសម្លេងរបស់គាត់នៅក្នុងកន្លែងសាធារណៈដែលពីមុនមកគឺថាគាត់អត់ហ៊ាននិយាយទេគាត់អត់ហ៊ាននិយាយគាត់បៀមទុកនៅរឿងហេតុទាំងអស់នោះនៅក្នុងចិត្តសូម្បីតែសមាជិកក្រុមគ្រួសារគាត់ជំនាន់ក្រោយគឺគាត់អត់សូវហ៊ាននិយាយដែរក៏ប៉ុន្តែសាវនាការនៃសំណុំរឿង002នេះគឺបានលើកទឹកចិត្តឲ្យជនរងគ្រោះក៏ដូចជាដើមបណ្ដឹងរដ្ឋវិន័យដើម្បីបញ្ចេញសម្លេងរបស់គាត់ដោយសេចក្តីក្លាហាន
ដើមបណ្ដឹងរដ្ឋប្រវេណីជាច្រើនរូបនៅក្នុងកំឡុងពេលឡើងផ្ដល់សក្ខីកម្មនៅសាលាក្តីខ្មែរក្រហមបានពិពណ៌នាពីការឈឺចាប់របស់ខ្លួននៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យនិងបានលើកឡើងផងដែរថាតាមពិតទៅពួកគាត់បានលាក់ការពិតនៃសាច់រឿងរបស់ពួកគាត់អស់រយៈពេលជាច្រើនឆ្នាំផងដែរ
បាទក្នុងការរស់នៅអង្គពីថ្មមិនដែលមានសេចក្តីសង្ឃឹមថានឹងរស់នៅបានសប្តាហ៍ថ្ងៃមកដល់សប្តាហ៍នេះទេដូច្នេះការសង្ឃឹមមានតែខ្លះគេពោលថាតែយប់ឡើងរស់ថ្ងៃឡើងគឺងាប់ខ្លះគេពោលថាតែយប់ឡើងថ្ងៃឡើងងាប់យប់ឡើងរស់សង្ឃឹមតែម្នាក់មួយថ្ងៃប៉ុណ្ណឹងឯងបាទមិនដែលមានថ្ងៃណាថាស្បែកចិត្ត
កាលនោះខ្ញុំអត់ហ៊ាននិយាយខ្ញុំខ្មាស់គេខ្ញុំលាក់ទុករហូតមកដល់ថ្ងៃនេះខ្ញុំអត់ដែលនិយាយប្រាប់អ្នកណាសូម្បីតែមួយម៉ាត់បើខ្ញុំនិយាយប្រាប់គេទៅខ្ញុំខ្មាស់គេម្ល៉េះហើយខ្ញុំទុកដល់មកឡើងមកដល់កន្លែងនេះខ្ញុំនឹងនិយាយឲ្យអស់បងប្អូនរួមជាតិអង្គការពិភពលោកទាំងអស់ឲ្យដឹងថាគេប្រព្រឹត្តមកលើរូបខ្ញុំបែបនេះមែន
សូមថ្លែងអំណរគុណយ៉ាងជ្រាលជ្រៅដល់ដើមបណ្ដឹងរដ្ឋប្រវេណីសាក្សីនិងមេធាវីទាំងអស់ដែលបានចំណាយពេលវេលាចូលរួមនៅក្នុងដំណើរការសវនាការនិងនៅក្នុងកម្មវិធីរបស់យើងព្រមទាំងចែករំលែកនូវសាច់រឿងនិងទស្សនៈផងដែរកម្មវិធីរបស់យើងនឹងត្រឡប់មកជួបទូរទស្សនិកជននៅឆ្នាំ2022ជាពេលដែលយើងរំពឹងថាអង្គជំនុំជម្រះតុលាការកំពូលនឹងប្រកាសសាលក្រមសេចក្តីសម្រេចវិនិច្ឆ័យនៃសំណុំរឿង 002/02 ពាក់ព័ន្ធនឹងលោកខៀវសំផនប៉ុន្តែនៅពេលនេះកម្មវិធីរបស់យើងក៏សូមថ្លែងអំណរគុណដល់ទូរទស្សនិកជនសាជាថ្មីដែលបានតាមដានទស្សនានៅកម្មវិធីប្រឈមមុខនឹងយុត្តិធម៌តាំងពីដើមរហូតដល់ចប់សូមអរគុណសូមជម្រាបលាសូមជម្រាបសួរនិងសូមស្វាគមន៍សាជាថ្មីមកកាន់កម្មវិធីចុងក្រោយនៃកម្មវិធីប្រឈមមុខនឹងយុត្តិធម៌នាងខ្ញុំរតនិមលសូមជម្រាបសួរចាប់តាំងពីថ្ងៃទី16ដល់ថ្ងៃទី19ខែសីហាអង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានបើកសវនាការបណ្ដឹងសារទុកចុងក្រោយនៃសំណុំរឿង002ពាក់ព័ន្ធនឹងជនត្រូវចោទខៀវសំផន នេះជាឱកាសចុងក្រោយរបស់លោកខៀវសំផនដើម្បីការពារខ្លួនគាត់និងព្យាយាមបដិសេធនៅការចោទប្រកាន់ពីឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍ឧក្រិដ្ឋកម្មប្រឆាំងមនុស្សជាតិនិងការរំលោភបំពានដ៏ធ្ងន់ធ្ងរលើសន្ធិសញ្ញាក្រុងហ្សឺណែវឆ្នាំ1949ក្នុងសំណុំរឿង002/02នៅសាលាក្តីខ្មែរក្រហមកាលពីសប្តាហ៍មុនកម្មវិធីយើងបានលើកយកមកបង្ហាញនៅព្រឹត្តិការណ៍នានាដែលបានកើតឡើងនៅសវនាការនៃបណ្ដឹងសារទុកនិងការតវ៉ារវាងព្រះរាជអាជ្ញានិងដើមបណ្ដឹងរដ្ឋបវេនីនិងក្រុមការពារក្តីដែលពាក់ព័ន្ធទៅនឹងការរកឃើញអង្គហេតុនិងផ្លូវច្បាប់របស់អង្គជំនុំជម្រះសាលាដំបងនៅក្នុងសំណុំរឿង002/02នៅថ្ងៃចុងក្រោយនៃសវនាការបណ្ដឹងសារទុកព្រះរាជអាជ្ញាមានឱកាសឆ្លើយតបទៅសំណួរចុងក្រោយថាហេតុអ្វីបានជាការចោទប្រកាន់និងការផ្ដន្ទាទោសនេះមិនគួរត្រូវបានគេបដិសេធ
In terms of the enemy's policy
ពាក់ព័ន្ធនឹងគោលនយោបាយអក្រិតនេះគាត់អត់មានបាននិយាយប្រឆាំងអីសោះហើយពាក់ព័ន្ធនឹងគោលនយោបាយប្រឆាំងនឹងខ្មាំងគាត់ផ្ដល់មតិយោបល់ថាខ្មាំងគ្រប់រូបភាពទាំងអស់គឺថាត្រូវតែកម្ចាត់ចោលឲ្យអស់ចឹងមន្ត្រីសាធារណរដ្ឋខ្មែរត្រូវកម្ចាត់ចោលឲ្យអស់បញ្ញវន្តពីរបបសាធារណរដ្ឋខ្មែរកម្ចាត់ចោលឲ្យអស់ខ្មាំងរបស់បដិវត្តរបស់បកត្រូវតែកម្ចាត់ចោលឲ្យអស់អញ្ចឹងគាត់អង្គុយឲ្យអនុញ្ញាតឲ្យអ្នកមិនត្រឹមតែអង្គុយឲ្យអ្នកដទៃទៀតអនុវត្តអញ្ចឹងទេប៉ុន្តែគាត់ផ្ដល់យោបល់ទាំងអស់គាត់ដឹងពីស្ថានភាពគាត់ដឹងពីស្ថានភាពទីសកលហើយគាត់ក៏បានផ្ដល់យោបល់ទៅដល់ការកម្ចាត់ខ្មាំងទាំងអស់ហ្នឹងផងដែរទោះបីជាយ៉ាងណាក្រមមេធាវីការពារក្តីបានបិទបញ្ចប់ការតវ៉ារបស់ខ្លួនដោយបដិសេធយ៉ាងដាច់អហង្ការចំពោះការចូលរួមពាក់ព័ន្ធឬក៏ទទួលខុសត្រូវលើឧក្រិដ្ឋកម្មរបស់កូនក្តីខ្លួនលោកខៀវសំផន
Il ne pouvait pas ne pas savoir
ខៀវសំផនហ្នឹងមិនអាចមិនដឹងបានទេហើយនេះជាលេសរបស់អង្គជំនុំជម្រះដែលខ្ញុំខាងព្រះអាជ្ញាខ្ញុំឬគាត់និយាយចឹងដែរហើយនិយាយដដែលហ្នឹងថាសាលាដំបងនឹងប្រើចំណុចនោះដើម្បីឲ្យដឹងថាខៀវសំផនហ្នឹងគាត់ដឹងរឿងរ៉ាវអីទាំងអស់អញ្ចឹងគាត់មានទំនួលខុសត្រូវបានន័យថាទម្លាក់កម្រិតចេតនាដើម្បីឲ្យគាត់ទទួលខុសត្រូវអញ្ចឹងគាត់មិនអាចដឹងបានទេខៀវសំផនត្រូវតែដឹងក៏ប៉ុន្តែនៅកម្ពុជាប្រជាធិបតេយ្យហ្នឹងគឺកាលណានៅចិត្តគ្នាហ្នឹងមិនមែនមានន័យថាយើងដឹងរឿងរ៉ាវទាំងអស់ទេសេពគប់គ្នានោះតាក់ទងនឹងច្បាប់ដែលអនុវត្តបានតាក់ទងនឹងសហឧក្រិដ្ឋកម្មរួមនោះតាក់ទងនឹងការជួយហើយនឹងជំរុញនេះគឺថាអង្គជំនុំជម្រះខំព្យាយាមប៉ះពៅដោយខ្វះផុសតាងហើយតាក់ទងនឹងអង្គើនិងអកប្បកិរិយារបស់ខៀវសំផនអញ្ចឹងហើយបានខ្ញុំសូមឲ្យតុលាការកំពូលបដិសេធចោលនៅការស្នើសុំផ្តន្ទាទោសលោកខៀវសំផន
ចៅក្រមអន្តរជាតិមួយរូបនៅក្នុងចំណោមចៅក្រមអន្តរជាតិទាំង3រូបគឺចៅក្រមចន្ទ្រានីលហាចៃយ៉ាស៊ីងមកពីប្រទេសស្រីលង្កាបានចោទសួរនៅសំណួរពិបាកជាច្រើនដល់សហព្រះរាជអាជ្ញាគាត់បានបង្ហាញពីការសង្ស័យដោយសាកសួរពីគុណភាពនៃភស្តុតាងដែលប្រើសម្រាប់ចោទប្រកាន់លោកខៀវសំផន
The evidence relied upon
ភស្តុតាងដែលបញ្ញាបានលើកឡើងគឺភស្តុតាងចិញ្ចាមអារាមឬក៏ភស្តុតាងតាមកលៈទេសៈភស្តុតាងទាំងអស់នោះវាមានលក្ខណៈជាលក្ខណៈដែលទទួលឥទ្ធិពលតើយើងអាចពឹងផ្អែកភស្តុតាងហ្នឹងតើយើងអាចជឿទុកចិត្តកម្រិតណា
we are of the view of course
យើងស្ថិតក្នុងស្ថានភាពមួយដោយដែលសាលាដំបងប្រឈមគឺយើងមានការប្រឈមតាក់ទងទៅនឹងភស្តុតាងនៅក្នុងសំណុំរឿងយើងការពិតអាការបង្ហាញឲ្យហួសពីវិមតិសង្ស័យគឺជាការប្រឈមលំបាកមួយផងដែរយើងយកស្របដូចនឹងអ្វីដែលអង្គជំនុំជម្រះសាលាដំបងគាត់វិភាគគឺថាជារួមសរុបទៅគឺភស្តុតាងអាចជឿបានហើយខ្ញុំស្របជាមួយនឹងការជំទាស់ដែលលោកចៅក្រមនិយាយ
ក្រោយមកទៀតចៅក្រមអន្តរជាតិដដែលនេះបានសាកសួរទៅសហព្រះរាជអាជ្ញាថាហេតុអ្វីបានជាចាំបាច់នៅក្នុងការផ្ដន្ទាទោសជនត្រូវចោទឲ្យជាប់ពន្ធនាគារអស់មួយជីវិតជាលើកទី2បន្ទាប់ពីគាត់ត្រូវបានចោទប្រកាន់និងផ្ដន្ទាទោសឲ្យជាប់ពន្ធនាគារអស់មួយជីវិតរួចទៅហើយនៅក្នុងសាលក្រមចុងក្រោយនៃសំណុំរឿង002/01កាលពីឆ្នាំ2018
My question is again
សំណួររបស់ខ្ញុំសួរទៅកាន់សហប្រញ្ញា ផងដែរតើមានយុទ្ធកម្មក្នុងការផ្ដន្ទាទោសមួយជីវិតចំពោះមនុស្សដែលមានអាយុ90ឆ្នាំហើយនេះដែរទេ
Thank you your honor
សូមអរគុណលោកចៅក្រមការពិចារណាបឋមទៅលើការផ្ដន្ទាទោសនិយាយអំពីភាពធ្ងន់ធ្ងរនិងស្ថានទម្ងន់របស់ជនចាប់ចោទស្ថិតក្នុងស្ថានភាពនេះគឺថាវាមានចំណុចសំខាន់លេចធ្លោដូចនៅពេលដែលយើងមានស្ថានទម្ងន់ធ្ងន់ធ្ងរនៃបទឧក្រិដ្ឋអញ្ចឹងការផ្ដន្ទាទោសតម្រូវឲ្យធ្វើដូច្នេះឯង បន្ទុកណាជាមានស្ថានសម្រាប់ក្តីក៏គេមិនអាចផ្ដន្ទាទោសឲ្យក្រោមការដាក់ទោសក្រោមកម្រិតអតិបរមាបានដែរ
កម្មវិធីយើងក៏បានសួរសំណួរដដែលខាងលើទៅកាន់ក្រុមមេធាវីការពារក្តីនិងសហបរិយាអាជ្ញានៅក្នុងបទសម្ភាសន៍ផ្សេងគ្នាហេតុអ្វីបានជាមានសារៈសំខាន់នៅក្នុងការកាត់ក្តីសវនាការបណ្ដឹងសារទុកនៃសំណុំរឿង 002/02 ឲ្យបានចប់សពគ្រប់បើទោះជាលោកខៀវសំផនត្រូវបានផ្ដន្ទាទោសឲ្យជាប់ពន្ធនាគារអស់មួយជីវិតនៅក្នុងសវនាការបណ្ដឹងសារទុកចុងក្រោយនៃសំណុំរឿង 002/01 រួចទៅហើយ
Well, it was two different trials.
ជាសវនកម្មពីរផ្សេងគ្នាហើយការចាប់ប្រកាន់ក៏ផ្សេងគ្នាដែរដែលមានចំណុចផ្លូវច្បាប់រួមគ្នាមួយចំនួននៅខណៈពេលដែលចំណុចផ្សេងទៀតខុសគ្នានេះជាការចាប់ប្រកាន់ផ្សេងមួយទៀតហើយគាត់មានសិទ្ធិក្នុងការដាក់បណ្ដឹងសារទុកហើយគាត់ក៏បានប្រើប្រាស់សិទ្ធិនោះពីព្រោះគាត់តវ៉ាប្រឆាំងនឹងការចាប់ប្រកាន់ដូចនេះហើយបានជាសវនកម្មនេះមានសារៈសំខាន់ហើយក៏មិនមែនជាសំណួរដែលត្រូវចោទសួរថាជាបណ្ដឹងសារទុកទី2តែជាបណ្ដឹងសារទុកនៃសវនកម្មទី2ដូច្នេះនេះជាសវនកម្មផ្សេងការចាប់ប្រកាន់ក៏ផ្សេងហើយក៏ជាសិទ្ធិក្នុងការដាក់បណ្ដឹងសារទុកផ្សេងមួយទៀត
អញ្ចឹងយើងត្រូវសំណុំរឿងក្រោយនេះគឺយើងពាក់ព័ន្ធទៅលើបទចោទផ្សេងទៀតដូចជាបលាយពុសាសដូចជាការរំលោភសិទ្ធិមនុស្សការធ្វើមនុស្សឲ្យទៅជាទាសករនៅក្នុងរបបនឹងអាហ្នឹងហើយនឹងការសម្លាប់បង្គាលការធ្វើទុកបុកម្នេញគ្រប់បែបយ៉ាងទាំងអស់នៅលើជនជាតិចាមជនជាតិវៀតណាមនៅក្នុងការស៊ើបអង្កេតរបស់ចក្រមស៊ើបអង្កេតក៏ដូចជាការចោទប្រកាន់របស់សហប្រញ្ញាតុលាការបានសម្រេចរកឃើញតុលាការគឺតុលាការសាលាដំបងក៏រកឃើញនៅបទឧក្រិដ្ឋទាំងឡាយហ្នឹងដែលគាត់បានប្រព្រឹត្តហើយនឹងសម្រេចដាក់ទៅគាត់មួយជីវិតថែមទៀតហើយឥឡូវនេះយើងបានតតាំងគ្នានៅសវនាការនឹងសំណុំរឿង 002/2 នេះយើងទាំងអស់គ្នាជាទូនាទីព្រះអាជ្ញាទូនាទីរបស់មេធាវីគឺថាដើម្បីបង្ហាញទៅតុលាការកំពូលថាយើងនឹងមានទូនាទីរៀងខ្លួនបង្ហាញទៅឲ្យតុលាការជឿជាក់ថាមានវិរុទ្ធភាពដោយអ្វីដែលយើងចាប់ប្រកាន់អត់អញ្ចឹងហើយបើសិនជារកឃើញហើយតុលាការកំពូលគាត់យល់ស្របយើងគាត់ប្រកាសជាសម្រាប់តាមយើងប៉ុន្តែបើគាត់ថាមិនសមហេតុសមផលនេះជាសិទ្ធិរបស់តុលាការគាត់នឹងសម្រេចទៅតាមនឹងដែរចាដូច្នេះវាមានន័យសំខាន់ចាដើម្បីលាតត្រដាងគ្រប់អង្គហេតុទាំងអស់ចានេះជាគោលបំណងនៃការកាត់ទោសនេះឯង
នៅទីបំផុតបន្ទាប់ពីសហប្ររាជអាជ្ញានិងមេធាវីបានបញ្ចប់នៅការតវ៉ារបស់ខ្លួនហើយចៅក្រមក៏បានបញ្ចប់ការសាកសួរលោកខៀវសំផនត្រូវបានផ្ដល់ឱកាសឲ្យឡើងថ្លែងជាចុងក្រោយនៅចំពោះមុខអង្គជំនុំជម្រះតុលាការកំពូលបន្ទាប់ពីដំណើរការកាត់ក្តីនៃសំណុំរឿង 002/02 អស់រយៈពេលជាង5ឆ្នាំនិងរយៈពេលជាង10ឆ្នាំចាប់តាំងពីគាត់ត្រូវបានគេស៊ើបអង្កេតនិងចោទប្រកាន់នៅក្នុងសំណុំរឿង 002 នេះប្រហែលជាពេលវេលាចុងក្រោយដែលគាត់បានថ្លែងនៅក្នុងសាលាកាត់ក្តីនៃសាលាក្តីខ្មែរក្រហមកម្មវិធីយើងសូមចែករំលែកនៅផ្នែកខ្លះៗនៃសេចក្តីថ្លែងការណ៍របស់គាត់ទូរទស្សនិកជនក៏អាចស្ដាប់ឮដោយផ្ទាល់នៅប្រសាសន៍របស់ជនជាប់ចោទរូបនេះ
ខ្ញុំបដិសេធដាច់អហង្ការការចោទប្រកាន់ដែលថាខ្ញុំមានចេតនាចង់ប្រព្រឹត្តអកតកម្មនៅពេលណាមួយក៏ដោយទោះជាអកតកម្មអ្វីក៏ដោយទោះជាអកតកម្មប្រឆាំងមនុស្សជាតិតាមរូបភាពណាមួយក៏ដោយបាទណាតាមរយៈខ្ញុំគេសម្ដៅបកកុម្មុយនីសកម្ពុជាឯនោះទៅវិញទេខ្ញុំមិនដែលចង់បានអ្វីក្រៅពីប្រទេសខ្ញុំឯករាជ្យអធិបតេយ្យដែលនៅក្នុងនោះបងប្អូនរួមជាតិខ្ញុំអាចរស់នៅបានហើយរួមគ្នាកសាងអនាគតមួយក្រោយពីបានស្ដារសេដ្ឋកិច្ចដែលត្រូវខ្ទេចទីដោយសង្គ្រាមអស់ជាច្រើនឆ្នាំជានិច្ចកាលខ្ញុំចង់ឲ្យកម្ពុជាស្ថិតនៅជាឯករាជ្យអធិបតេយ្យ ដែលព្រំដែនរបស់ខ្លួនត្រូវបានប្រទេសជិតខាងគោរពពិសេសវៀតណាមខ្ញុំសូមប្រកាសថាខ្ញុំមិនអាចទទួលបានទេការចោទប្រកាន់ដែលថាខ្ញុំបានចូលរួមនៅក្នុងផែនការមួយដែលមានទិសដៅប្រព្រឹត្តអក្រិតកម្មលើបងប្អូនរួមជាតិឯងក្នុងនោះរំរាប់ទាំងបងប្អូនចាមឬជនជាតិវៀតណាមទោះបីអស់លោកសម្រាប់យ៉ាងណាក៏ដោយខ្ញុំនឹងត្រូវស្លាប់នៅក្នុងគុកខ្ញុំស្លាប់ទៅដោយចងចាំជានិច្ចទុក្ខសោកវេទនារបស់ប្រជាជនកម្ពុជាខ្ញុំស្លាប់ទៅដោយសង្កេតឃើញថាខ្ញុំម្នាក់ឯងចំពោះមុខអស់លោកត្រូវបានគេកាត់ទោសជានិមិត្តរូបជាជាងតាមអំពើប្រព្រឹត្តជាក់ស្ដែងរបស់ខ្ញុំក្នុងឋានៈជាបុគ្គលនោះទេ
កម្មវិធីយើងបានសាកសួរក្រុមមេធាវីការពីក្តីរបស់លោកខៀវសំផននិងសហប្រតិអាជ្ញាជាតិលោកជំទាវជាលៀងពីអារម្មណ៍របស់ពួកគាត់នៅពេលដំណើរការសវនាការបណ្ដឹងសារទុកនិងទស្សនៈរបស់ពួកគាត់ចំពោះសេចក្តីថ្លែងការណ៍ចុងក្រោយរបស់លោកខៀវសំផន
Whatever the questions are
ទោះជាសំណួរជាច្រើនត្រូវបានចោទសួរនៅក្នុងសារកាត់ក្តីមិនមែនបានសេចក្តីថាសំណួរទាំងនោះបញ្ជាក់ពីស្ថានភាពនៃសារក្រមសេចក្តីសម្រេចបណ្ដឹងសារទុកនោះដែរជាកត្តាល្អយ៉ាងហោចណាស់ក៏មានចំណុចមួយចំនួនដែលយើងបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកត្រូវបានគេលើកយកមកបង្ហាញនៅពេលដែលនិយាយពីលទ្ធផលយើងត្រូវរងចាំឲ្យចៅក្រមពិភាក្សាវែកញែកហើយខ្ញុំមិនច្បាស់ថាលទ្ធផលនឹងចេញមកបែបណានោះដែរប៉ុន្តែយ៉ាងហោចណាស់ក៏ល្អដែរពីព្រោះវាជាអ្វីដែលយើងបានរំលឹកចេញតាមពិតទៅខាងបរិយាអាញាមានឆន្ទៈក្នុងការដាក់លោកខៀវសំផននៅក្នុងភាពស្រពេចស្រពើនៃគោលគំនិតរបស់មជ្ឈិមបកហើយយើងក៏បានរំលឹកចេញនៅភាពមិនប្រក្រតីនៃអង្គជំនុំជម្រះនៅក្នុងលក្ខខណ្ឌនេះដូចនេះបើចៅក្រមយ៉ាងហោចណាស់ក៏មានចៅក្រមម្នាក់ដែលកត់សម្គាល់ឃើញចំណុចនេះហើយដែលជារឿងល្អមួយ
គាត់មានសំអាងអីបញ្ជាក់បន្ថែមទេឬមួយក៏ប្រញ្ញាថាគាត់ធ្វើនឹងឆ្លើយតបនឹងមានការសមហេតុនិងមានភ័ស្តុតាងអីបង្ហាញឲ្យអង្គជំនុំជម្រះអត់អញ្ចឹងផ្នែកធំបំផុតគឺនៅលើការសរសេរជាលិខិតអក្សររយៈពេល4ថ្ងៃវាមិនគ្រប់គ្រាន់ទេក្នុងសំណុំរឿងដែលធំហើយដែលយើងមានសាក់សីរាប់ម៉ឺននាក់ដូច្នេះវាសំបីតែមន្ទីរសន្តិសុខហ្នឹងក៏វាច្រើនដែរវាមិនអាចបកស្រាយនៅគ្រប់មន្ទីរសន្តិសុខទាំងអស់នឹងបានទេអញ្ចឹងធ្វើនៅដូចជាសង្ខេបប៉ុន្តែទាល់តែច្បាស់តើយើងអាននៅលើឯកសារដែលជឿនៅក្នុងប្រព័ន្ធអេឡិចត្រូនិកហើយអនាគតគេនឹងដាក់ជាសាធារណៈដើម្បីឲ្យយើងទាំងអស់គ្នាអាចអានបានប៉ុន្តែអ្វីដែលខ្ញុំចាប់អារម្មណ៍ដែរដំណាក់កាលពេលនេះលើជនជាប់ចោទខៀវសំផនគាត់មិនបាននិយាយអីច្រើនទេហើយមេធាវីរបស់គាត់ក៏ប្រឹងប្រែងព្យាយាមក្នុងការការពារកូនក្តីរបស់គាត់
នៅពេលនេះសវនាការបណ្ដឹងសារទុកត្រូវបានបិទបញ្ចប់កម្មវិធីយើងចង់ដឹងថាមានអ្វីកើតឡើងបន្តទៅទៀតបន្ទាប់ពីនេះតើតុលាការត្រូវប្រើរយៈពេលប៉ុន្មានដើម្បីអាចចេញសារក្រមសេចក្តីសម្រេចវិនិច្ឆ័យប្រឆាំងនឹងលោកខៀវសំផនកម្មវិធីយើងបានជួបជាមួយលោកណេតភក្ត្រាអ្នកនាំពាក្យសាលាក្តីខ្មែរក្រហមដើម្បីបានព័ត៌មានពីបញ្ហានេះ
ហើយតាមការរំពឹងទុកសាលដីការបស់អង្គជំនុំជម្រះតុលាការកំពូលចំពោះបណ្ដឹងសារទុករបស់លោកខៀវសំផននេះរំពឹងថានឹងប្រកាសនៅចុងឆ្នាំ2022ខាងមុខបន្ទាប់ពីដំណើរការសវនាការនៅខែសីហាឆ្នាំ2021នេះហើយចៅក្រមគាត់នឹងពិនិត្យទៅលើអង្គច្បាប់និងផ្នែកពាក់ព័ន្ធនានាដែលជាបណ្ដឹងសារទុករបស់ភាគីពាក់ព័ន្ធនានានៅក្នុងនោះមិនមែនត្រឹមតែភាគីដើមចោតទេក៏មានភាគីព្រះរាជអាជ្ញាដែលគាត់ស្នើសុំឲ្យមានការពិនិត្យបន្ថែមផងដែរបាទ
ចាបើតាមមើលសំណុំរឿង002/02ប្រហែលជាសវនាការចុងក្រោយដែលត្រូវដំណើរការនៅសាលាក្តីខ្មែរក្រហម ប៉ុន្តែយើងចាំបាច់ត្រូវគិតពីកេរដំណែលរយៈពេលវែងដែលបន្សល់ទុកដោយសាលាក្តីខ្មែរក្រហមសម្រាប់ប្រព័ន្ធតុលាការនៅកម្ពុជានិងសហគមន៍ផងដែរកម្មវិធីយើងចង់ដឹងថាតើយើងបានរៀនអ្វីខ្លះពីដំណើរការជាប្រវត្តិសាស្ត្រនេះតើមានអ្វីបន្សល់ទុកសម្រាប់ប្រជាជនកម្ពុជាយើងបន្ទាប់ពីទ្វារសាលាក្តីត្រូវបានបិទជាដំបូងកម្មវិធីយើងបានជួបពិភាក្សាជាមួយមេធាវីដែលធ្វើការនៅអង្គជំនុំជម្រះតុលាការកំពូលឬរដ្ឋបាលតុលាការពលគឺពួកគេនៅពីក្រោយព្រឹត្តិការណ៍សំខាន់ៗនៅសាលាក្តីខ្មែរក្រហម
តុលាការនេះបានប្រព្រឹត្តទៅបានដោយជោគជ័យហើយតុលាការនេះគឺស្ថិតនៅក្នុងតុលាការកម្ពុជាដោយមានជំនួយបច្ចេកទេសពីអង្គការសហប្រជាជាតិបានធ្វើទៅរួចបានដោយជោគជ័យហើយយើងបានបង្រួមជាតិមិនបានបំបែកបបាក់នៅក្នុងសហគមន៍នោះទេហើយផលប្រយោជន៍ផ្សេងទៀតដូចជាផ្ដល់នៅយុទ្ធសាស្ត្រក៏ដូចជានីតិវិធីនិងច្បាប់សារធាតុមួយចំនួនបង្រៀនទៅដល់ធនធានមនុស្សបានកាន់តែច្រើននិងផ្នែកប្រវត្តិសាស្ត្រតុលាការអវតកនេះបានបំពេញនៅតម្រូវការស្រាវជ្រាវផ្នែកប្រវត្តិសាស្ត្រពីព្រោះថាការស្រាវជ្រាវប្រវត្តិសាស្ត្រធម្មតាមិនអាចនឹងសម្ភាសបានទៅដល់ជនដៃដល់ថ្នាក់លើដែលមានការរសើបបានទេប៉ុន្តែតុលាការយើងនេះដោយមានការសហការល្អរបស់ជំនួយបច្ចេកទេសអង្គការសហប្រជាជាតិនិងរដ្ឋាភិបាលផងគឺយើងអាចសម្ភាសបានដែលជាការបំពេញការខ្វះខាតហើយខ្ញុំឃើញមានរដ្ឋាភិបាលបានដាក់ចូលទៅក្នុងកម្មវិធីអប់រំជាផ្លូវការនៅមធ្យមសិក្សាទុតិយភូមិផង
ព្រោះ14ឆ្នាំកន្លងមកនេះដែលខ្ញុំបានធ្វើការដែលអាចឲ្យខ្ញុំរៀននិងអភិវឌ្ឍជំនាញរបស់ខ្លួនខ្ញុំដែលជាមេធាវីនេះចាអញ្ចឹងវាគឺជាកេរដំណែលដែលមិនអាចកាត់ថ្លៃបានទេតាំងការងារកំពុងតែធ្វើរាល់ថ្ងៃនិងទៅថ្ងៃអនាគតនៅពេលដែលខ្ញុំបញ្ចប់ការងារពីទីនេះហើយយកទៅអនុវត្តផ្ទាល់នៅជំនាញរបស់ខ្ញុំដែលជាមេធាវីចាពិតប្រាកដណាស់ពួកគេច្បាស់ជានាំបទពិសោធន៍និងចំណេះដឹងស្តង់ដារការងារនៅទីនេះទៅអនុវត្តនៅក្នុងប្រព័ន្ធតុលាការរបស់ជាតិយើងទៅតាមលទ្ធភាពដែលពួកគេអាចធ្វើបានហើយយើងទាំងអស់គ្នាក៏ចង់នាំយកវិធីទាំងអស់នេះទៅធ្វើការនៅក្នុងប្រព័ន្ធរបស់ជាតិយើងដូចគ្នាទៅតាមលទ្ធភាពដែលយើងអាចធ្វើបានហើយទាំងអ្នកច្បាប់ទាំងមេធាវីឬក៏ទាំងលោកចៅក្រមខ្ញុំជឿថាពួកគាត់បាននាំទៅខ្លះហើយ
កម្មវិធីយើងក៏បានសាកសួរសហប្រតិអាជ្ញាអន្តរជាតិនិងសហប្រតិអាជ្ញាជាតិក៏ដូចជាមេធាវីមកពីសាលាក្តីខ្មែរក្រហមពីអ្វីដែលគាត់យល់ថាជាកេរដំណែលដែលតុលាការបានបន្សល់ទុកឲ្យប្រព័ន្ធតុលាការកម្ពុជានៅពេលអនាគតបន្ទាប់ពីការបិទបញ្ចប់សំណុំរឿង002
Dealing with the past is important.
ការប្រឈមដោះស្រាយបញ្ហាការពីអតីតកាលជាការចាំបាច់អតីតកាលប្រាប់ដល់អនាគតនៅវិសាលភាពតិចឬច្រើនអាស្រ័យទៅលើថាយើងជឿជាក់ឬក៏យើងសិក្សាពីអតីតកាលបានកម្រិតណាប៉ុន្តែប្រហែលជាវាមានសារៈសំខាន់ជាងសម្រាប់យុវជនជំនាន់ក្រោយនៅសមត្ថភាពក្នុងការតម្រង់នៅអនាគតតាមមធ្យោបាយជាច្រើនផ្សេងៗគ្នាតាមរយៈបទពិសោធន៍នៅកំណត់ត្រាប្រវត្តិសាស្ត្រដែលបានសិក្សាដើម្បីជៀសវាងនៅកលៈទេសៈដែលនាំទៅដល់របបខ្មៅងងឹតប្រវត្តិសាស្ត្រកម្ពុជា
ការរក្សាឯកសារការប្រើប្រព័ន្ធបច្ចេកវិទ្យាគឺមានការរីកចម្រើនមន្ត្រីយើងរៀនសូត្រច្រើនដែលយើងគិតថាយើងមិនទាន់ឈានដល់នៅជាតិយើងមិនទាន់ឈានដល់កម្រិតហ្នឹងប៉ុន្តែអ្នកទាំងនោះនឹងយកចំណេះដឹងនិងការប្រើប្រាស់ទីនោះមករៀបចំនៅតុលាការជាតិនេះជាអ្វីមួយដែលល្អហើយសង្ឃឹមថាអ្វីដែលមួយទៀតគឺយើងបានយកអ្វីដែលកើតនៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យហ្នឹងហើយបង្កើតជាសាវនាការរកឃើញដើម្បីបំបត្តិនីតិរដ្ឋភាពហើយបានយកកម្មវិធីនេះទៅបង្រៀនគឺបង្រៀនក្មេងជំនាន់ក្រោយនៅតាមឥឡូវហ្នឹងរហូតដល់ក្រសួងអប់រំបានយកកម្មវិធីនេះទៅបង្រៀនឲ្យក្មេងយល់អំពីថាអ្វីដែលកន្លងមកបានកើតនៅប្រទេសកម្ពុជាក្នុងកំឡុងឆ្នាំ1975ដល់ឆ្នាំ1979នេះឯងអញ្ចឹងដើម្បីឲ្យក្មេងនឹងក៏ដឹងថាអ្វីវាកើតមកវារបៀបម៉េចហើយនឹងកុំឲ្យមានរបបនឹងកើតឡើងសារជាថ្មីអញ្ចឹងខ្ញុំគិតថាតុលាការនឹងផ្ដល់យុត្តិធម៌ឲ្យជនរងគ្រោះជនចាប់ចោតក៏ដូចជាដើមនឹងរដ្ឋបព្វនីដើម្បីឲ្យគាត់ស្ងប់អារម្មណ៍គិតថាសិក្សាលេខានឹងផ្ដល់ឲ្យគាត់នៅការស្ងប់អារម្មណ៍ល្អហើយទទួលយកទាំងអស់គ្នាអានេះដែលអ្វីដែលខ្ញុំគិតថាចំណុចសំខាន់ដែលបន្សល់សម្រាប់យើងនៅប្រទេសកម្ពុជានេះឯង
I've been working almost 10 years of my life on this case.
ខ្ញុំបានធ្វើការងារក្នុងសំណុំរឿងនេះស្ទើរតែពេញ10ឆ្នាំនៃជីវិតខ្ញុំវាឈានចូលដំណាក់កាលកាន់តែពិបាកទៅនៃប្រវត្តិសាស្ត្រសម្រាប់កម្ពុជាខ្ញុំសង្ឃឹមថាសាធារណជននឹងយល់ពីខាងក្រមការពារក្តីថាមិនមែនជាការធ្វើឲ្យរឿងរ៉ាវដែលបានកើតឡើងកាន់តែតូចទៅនោះទេសំណួរសួរថាតើអ្វីទៅជាការទទួលខុសត្រូវរបស់កូនក្តីខ្ញុំនៅក្នុងរឿងរ៉ាវទាំងនោះហើយមិនមែនព្រោះតែទូនាទីរបស់អ្នកដែលខ្ញុំស្គាល់នោះទេប៉ុន្តែជាអំណាចពិតប្រាកដរបស់គាត់និងការពាក់ព័ន្ធពិតប្រាកដនៅក្នុងអក្រិតកម្មដែលបានប្រព្រឹត្តឡើងប៉ុន្តែខ្ញុំគិតថាពេលប្រជាពលរដ្ឋត្រឡប់ទៅពិនិត្យមើលវាហើយប្រើពេលអានរាល់ឯកសារដែលសរសេរពីបកនៅក្នុងសំណុំរឿងនេះខ្ញុំគិតថាវានឹងឆ្លុះបញ្ចាំងបានយ៉ាងល្អទៅនឹងវិសាលភាពធំធេងនៃសំណុំរឿងនេះហើយសារៈសំខាន់នៃបញ្ហាផ្នែកច្បាប់ដែលគេដោះស្រាយនៅក្នុងសាលាក្តីខ្មែរក្រហមនេះដូចនេះវាអាស្រ័យទៅលើប្រជាជនជាអ្នកឆ្លុះបញ្ចាំងនិងពិនិត្យមើលថាតើតុលាការខ្មែរក្រហមធ្វើការងារខ្លួនបានល្អហើយឬនៅ
សម្រាប់អ្នកវិជ្ជាជីវៈចៅក្រមព្រះអាជ្ញាឬក៏ជាមេធាវីឬក៏ជាកលាវិជ្ជាអ្នករដ្ឋបាលជាដើម
សូមជើញក្រោកឈរ បាទសូមអញ្ជើញអង្គុយចុះ តាំងនាមអង្គការសហប្រជាជាតិតាំងនាមប្រជារាស្ត្រខ្មែរថ្ងៃនេះអង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាសម្រាប់កាត់សេចក្តីអក្រិតកម្មដែលបានប្រព្រឹត្តឡើងក្នុងអំឡុងពេលនៃរបបកម្ពុជាប្រជាធិបតេយ្យប្រកាសបន្តប្រកាសសាលដីកាស្ថាពរលើសារបណ្ដឹងសាទុករបស់ខៀវសំផននិងសហព្រះរាជអាជ្ញាក្នុងសំណុំរឿងលេខ 002/02 សមាជិកភាពក្រុមប្រឹក្សាជំនុំជម្រះនៅដដែលប៉ុន្តែលើកលែងតែចក្រមម៉ូរិនហាឌីងខ្លាកដែលបានសុំលាលែងពីអវតកហើយអង្គជំនុំជម្រះតុលាការកំពូលបានបញ្ចូលចក្រមជំនួសចក្រមបំរុងហ្វីលីបរ៉ាប៉ូសាដើម្បីបន្តកិច្ចដំណើរការនីតិវិធីខ្ញុំសូមជម្រាបផងដែរថាចៅក្រមហ្វីលីបរ៉ាប៉ូសាបានតាមដាននៅកិច្ចដំណើរការនីតិវិធីនៅអង្គជំនុំជម្រះនេះនៅពេលសវនាការនិងសំណុំរឿង 002/02 នេះតាំងពីដើមរហូតមកដល់ពេលនេះដូច្នេះគាត់មានសិទ្ធិគ្រប់គ្រាន់ក្នុងការបន្តសវនាការលើសំណុំរឿងនេះក្រឡាបញ្ជីសូមរាយការណ៍អំពីវត្តមានរបស់ភាគីនិងមេធាវីសូមអញ្ជើញបាទសូមគោរពប្រសាសន៍អាយដាមប្រធាននិងក្រុមអាយដាមលោកជំទាវក្រុមប្រឹក្សាជំនុំជម្រះទាំងអស់ភាគីទាំងអស់មានវត្តមានគ្រប់រូបហើយជនស្ថានភាពសុខភាពរបស់ជនជាប់ចោទគឺសម្ផននៅព្រឹកនេះមានលំនឹងល្អបង្គួរដែលគាត់អាចអនុញ្ញាតឲ្យគាត់អាចចូលរួមសវនាការបានដោយតាមដានការប្រែប្រួលស្ថានភាពសុខភាពរបស់គាត់ដោយក្រុមថែទាំសុខភាពផ្ទាល់សូមគោរពអរគុណរឿងក្តីបច្ចុប្បន្ននេះហៅថាសំណុំរឿងលេខ 002 ពាក់ព័ន្ធទៅនឹងព្រឹត្តិការណ៍ព្រៃផ្សៃបំផុតមួយចំនួនដែលបានកើតឡើងក្នុងចំណោមមហាសោកនាដកម្មនិងមហន្តរាយក្នុងប្រវត្តិសាស្ត្រមនុស្សជាតិនៅចន្លោះពីថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979បកកុម្មុយនីសកម្ពុជាដែលត្រូវបានស្គាល់ថាជាខ្មែរក្រហមបានគ្រប់គ្រងប្រទេសកម្ពុជាដែលក្រោយមកត្រូវបានបដូរទៅជាកម្ពុជាប្រជាធិបតេយ្យក្រោយពីដណ្ដើមបានអំណាចបកកុម្មុយនីសកម្ពុជាបានអនុវត្តបដិសេធសង្គមនិយមទូទាំងប្រទេសតាមរយៈទ្រឹស្ដីមហាលោតផ្លោះមហាអស្ចារ្យក្នុងគោលបំណងកសាងប្រទេសការពារពីខ្មាំងសត្រូវនិងកែប្រែប្រជាជនទាំងស្រុងឲ្យคล้ายទៅជាសង្គមកម្មករកសិករខ្មែរមួយដូចគ្នានិងគ្មានការប្រតិបត្តិសាសនាក្នុងអំឡុងពេលនៃរបបកម្ពុជាប្រជាធិបតេយ្យប្រជាជនស៊ីវិលត្រូវបានដកសិទ្ធិសេរីភាពជាមូលដ្ឋាននិងដាក់ឲ្យស្ថិតនៅក្រោមអំពើឃោរឃៅហួសប្រមាណលើដែលរីករាលដាលវប្បធម៌ភ័យខ្លាចមានអតិភិបគ្រប់ទីកន្លែងដែលរយៈ
តាមរយៈការសម្លាប់ទ្រង់ទ្រាយធំការធ្វើទារុណកម្មអំពើហិង្សាការធ្វើទុកបុកម្នេញការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំការធ្វើការដោយបង្ខំការធ្វើឲ្យបាត់ខ្លួនដោយបង្ខំនិងអំពើអមនុស្សធម៌ដទៃទៀតក្រោមការគ្រប់គ្រងរបស់បកកុម្មុយនីសកម្ពុជាដែលស្ថិតក្នុងចំណោមរបបឃោឃៅហួសហេតុជាងគេបំផុតនៅក្នុងសតវត្សទី20បានបណ្ដាលឲ្យមានការបាត់បង់ជីវិតប្រជាជនកម្ពុជាប្រមាណពី 1.5 ទៅ 2 លាននាក់រឿងក្តីនេះមានទំហំធំធេងនិងស្មុគស្មាញការបំបែកនៃការដំណោះស្រាយសំណុំរឿង002ត្រូវបានតម្រូវឲ្យមានការជំនុំជម្រះពីបន្តបន្ទាប់គ្នាលើបទចោទដាច់ដោយឡែកពីគ្នាសម្រាប់ជនជាប់ចោទ4នាក់ដូចគ្នាដែលវិធានការនេះធ្វើឡើងសម្រាប់គោលបំណងនៃការគ្រប់គ្រងការជំនុំជម្រះព្រមទាំងសុខភាពវ័យចាស់ជរារបស់ជនជាប់ចោទទាំង3ក្នុងចំណោម4នាក់ដែលត្រូវបានចោទប្រកាន់កន្លងមកបានទទួលមរណភាពឯកសារភាគច្រើនក្នុងសំណុំរឿងត្រូវបានបកប្រែជា3ភាសាផ្លូវការរបស់អវតកក្រោយពីការប្រឈមជាច្រើននេះពិភពលោកបានជួបប្រទះជំងឺ COVID-19 ដែលតម្រូវឲ្យកិច្ចខិតខំប្រឹងប្រែងយ៉ាងខ្លាំងក្នុងលក្ខណៈបត់បែននិងច្នៃប្រឌិតពីសំណាក់បុគ្គលិកនីមួយៗនៃស្ថាប័នតុលាការក្នុងការបន្តនីតិវិធីរឿងក្តីឲ្យដំណើរការទៅមុខដោយគ្មានការអាក់ខានក្នុងការចេញសារដីកានេះអាស្រ័យហេតុនេះបញ្ហាផ្នែកនីតិវិធីផ្នែកអង្គហេតុនិងអង្គច្បាប់ដែលអាចប្តឹងសាទុកបានត្រូវបានពិចារណាត្រឹមត្រូវនិងសម្រេចដោយចៅក្រមទាំងអស់នៃអង្គជំនុំជម្រះតុលាការកំពូលបន្ថែមលើនេះដោយពិចារណាលើបញ្ហាសុខភាពនិងវ័យចាស់ជរារបស់ជនជាប់ចោទអង្គជំនុំជម្រះតុលាការកំពូល
considered and decided by all judges of the Supreme Court chamber. Furthermore, the chamber, mindful of the accused's continued frail health and advanced age, considers it judicially prudent to ensure that the judgment is pronounced expeditiously. The judgment in this case concerns KHIEU SAMPHAN, who was found criminally responsible for his role in events involving the Khmer Rouge following a lengthy trial. The appeal judgment is several hundred pages long. I will now pronounce a summary that highlights only the key findings and rulings of the Supreme Court chamber in its deposition of this case. The full text of the judgment will be made available in due course after the editorial and translation process is completed. Only the full written judgment is authoritative. KHIEU SAMPHAN was born in Svayrieng province in 1931 and had a long and significant political career in Cambodia. He became a member of the circle of the leftist Khmer intellectuals studying in Paris in the 1950s while pursuing university and doctoral studies in France. He eventually rose to prominence both in the run-up to and during the DK era, holding various high-level positions in the CPK, including President of the State Presidium and in the government of DK. On 16 November 2018, the trial chamber of the ECCC rendered its judgment in case 002/02 in summary form and notified its full written judgment on 28 March 2019. In that judgment, the trial chamber found KHIEU SAMPHAN guilty of the crimes against humanity of murder, extermination, deportation, enslavement, imprisonment, torture, persecution on political, religious, and racial grounds, and other inhumane acts comprising conduct characterized as enforced disappearances, forced transfer, forced marriage, and rape in the context of forced marriage, and attacks against dignity against human dignity. KHIEU SAMPHAN was also convicted of both genocide by killing members of the Vietnamese population and grave breaches of the Geneva Conventions, namely willful killing, torture, inhuman treatment, willfully causing great suffering or serious injury to body or health, willfully depriving prisoners of war or civilians the rights of fair and regular trials, and the unlawful confinement of civilians. The trial chamber found that although KHIEU SAMPHAN did not commit these crimes with his own hands, he was criminally liable for most of them as part of a joint criminal enterprise, and for some of them by aiding and abetting their commission. The trial chamber imposed a sentence of life imprisonment on KHIEU SAMPHAN, merged it with the life sentence imposed on him in case 002/01, and ordered that the sentences be served concurrently. It also partially granted the civil parties' request for moral and collective reparations and endorsed 13 specific communal memorial projects. KHIEU SAMPHAN and the co-prosecutors filed appeal briefs and separate responses, and the civil party lead co-lawyers made written submissions on behalf of the civil parties. On appeal, KHIEU SAMPHAN alleges that the trial chamber committed approximately 1,824 errors and challenges the bulk of the trial judgment. In doing so, he alleges error in the issuance and pronouncement of the judgment by the trial chamber, and also alleges errors relating to the fairness of the proceedings, the scope of the judicial investigation and trial, the underlying crimes, and the issue of individual criminal responsibility. He asserts that the alleged errors require that his conviction be reversed and his sentence be vacated. The Supreme Court chamber notes, however, that KHIEU SAMPHAN makes no apparent challenges to the trial chamber's specific findings regarding the charge of grave breaches of the Geneva Conventions, although his appeal cites a number of errors that called into question the general integrity of the proceedings before the trial chamber. That would also apply to its consideration of that charge. His appeal relating to the grave breaches of the Geneva Conventions is limited to those alleged errors. The co-prosecutors advance a single ground of appeal, challenging the trial chamber's ruling that forced sexual intercourse in the context of forced marriage did not constitute the crime against humanity of other inhuman acts in the case of male victims. The Supreme Court chamber heard the parties' oral submissions on the appeals from 16 to 19 August 2021. The chamber then retired to deliberate, and today it renders its judgment on both appeals, which I shall address together as is done in the full written judgment. Due to the significant number of appeal challenges raised by KHIEU SAMPHAN, at this hearing I shall pronounce only a summary of our findings and rulings along with the disposition. The Supreme Court Chamber's findings and rulings with respect to both appeals are set out in its full written judgment, which will be notified in due course. I reiterate that it is the full written judgment that is authoritative. A summary of the challenges on appeal are addressed sequentially as follows. Alleged errors related to fairness of proceedings. As a preliminary matter, KHIEU SAMPHAN contends that by failing to issue the full written judgment on the day that it was announced in a summary form, the trial chamber committed a serious error of law that rendered the pronouncement of the judgment procedurally defective and thus void. Moreover, he argues that the subsequent issuance of the full written judgment did not cure the defect. He asserts that the trial judges were functus officio when the full written judgment was notified, and that the rest of his appeal is therefore rendered most moot because his guilt or innocence was never lawfully adjudicated. The Supreme Court Chamber notes that KHIEU SAMPHAN was fully aware of the trial chamber's intention to deliver a summary of the judgment with the full written judgment to follow. The trial chamber publicly provided notice of its intention to do so and provided ample opportunity to the parties to raise any objections, and none were raised. Internal Rule 102.1 provides that judgments shall be issued and announced during a public hearing, and that a summary of the findings and the disposition shall be read aloud by the President or other judge of the Chamber. The same rule also provides that the greffier shall distribute a copy of the judgment to the parties and ensure that it is published by the Office of Administration by appropriate means. Noting in this rule specifies, however, that such distribution or publication of the judgment must take place on the same day as the public hearing. In fact, it is not uncommon in international criminal cases of such magnitude to issue an oral summary of the judgment with written reasons to follow to allow for completion of the editorial and or translation processes. A trial judgment was thus lawfully issued and announced on 16 November 2018 in a summary form, although the full written version was distributed and published on 28 March 2019. KHIEU SAMPHAN's right to review the judgment underpinning both his convictions and his sentence remained wholly intact pending the distribution and publication of the judgment, as evidenced by the present adjudication of his appeal against the trial chamber's judgment. His submission in this respect is accordingly dismissed. KHIEU SAMPHAN further submits that over the course of the trial proceedings in case 002/02, his fundamental rights, as recognized under the legal framework of the ECCC, have not been respected as a result of the trial chamber's biased approach to the guiding principles of criminal proceedings and the rule of evidence. He argues that this fundamentally flawed approach led the trial chamber to repeatedly violate the majority of his fair trial rights and prevented it from making its findings and rulings in a fair and reasonable manner, resulting in numerous errors during the trial. His allegations of bias further extend to the trial chamber severance of case 002. He accused that the cumulative effect of these errors rendered the entire trial unfair, and he asked the Supreme Court chamber to reverse his convictions and his sentence. The Supreme Court chamber notes that with respect to his claim of bias on the part of the trial chamber, KHIEU SAMPHAN repeats his previous allegation that the case 00201 trial judgment prejudged his guilt in case 002/02, asserting that it would be impossible for the trial chamber to ignore its verdict in the previous case when deciding how to adjudicate the subsequent one. These are not novel issues and have previously been the subject of KHIEU SAMPHAN's application for disqualification of the trial and Supreme Court judges in 2014 and in 2019 respectively. A specially appointed panel of judges fully considered and dismissed the allegations of bias. In the absence of new substantiated allegations sufficient to rebut the judge's presumption of impartiality, these claims of bias are summarily dismissed. KHIEU SAMPHAN's additional allegations that the trial chamber was not impartial as to the manner in which it examined the evidence and committed other violations of his fair trial rights and the fairness of the proceedings are similarly dismissed as being without foundation for reasons explained in the full written judgment. Alleged errors related to the scope of the judicial investigation and trial. Turning to his allegations concerning Saisin, KHIEU SAMPHAN raises 5 main challenges relating to the scope of the judicial investigation and trial, namely that the trial chamber erred by 1. Characterizing his request relating to the scope of the investigation as belated preliminary objections under Rule 89 and finding them inadmissible. 2. Dismissing his arguments concerning the insufficiency of the charges against him due to their lack of clarity. 3. Ignoring his arguments that it could not adjudicate facts that were not accepted and not legally qualified by the co-investigating judges, causing it to exceed the scope of its referral. 4. Delivering a judgment on facts that it had already adjudicated in case 002/01 or on facts that it excluded from case 002/02 and for which the proceedings were terminated. And 5. Considering the out of scope but relevant evidence about facts of which it was not seized. I will summarize the Supreme Court chamber findings regarding those 5 challenges sequentially. Concerning his first argument, the Supreme Court chamber agrees with the co-prosecutors that since KHIEU SAMPHAN challenges the assessment of the trial chamber based on the alleged defects in the closing order and not the jurisdiction of the ECCC itself, his challenges do not fall within the remit of absolute jurisdiction and thus subject to KHIEU through adequate notice of the charges. Accordingly, the trial chamber did not err in holding that KHIEU SAMPHAN's objections were subject to the deadline prescribed by Internal Rule 89.1. As to his second argument, for reasons explained in the full written judgment, the Supreme Court Chambers finds no error in the trial chamber's dismissal of his submission concerning the insufficiency of the charges against him due to the alleged lack of clarity. Regarding his third argument, the Supreme Court Chamber finds that the trial chamber did not err in law in determining its sentient of the facts contained in the closing order. It has considered KHIEU SAMPHAN's arguments concerning the scope of the trial chamber's referral and finds that he has not demonstrated any error on the part of the trial chamber for reasons explained in the full written judgment. Relative to his fourth argument, the Supreme Court Chamber is not persuaded that the trial chamber erred by delivering a judgment on facts that it had already adjudicated in case 002/01 or on facts that it excluded from case 002/02 and for which the proceedings were terminated for reasons explained in the full written judgment. Finally, as to his fifth argument that the trial chamber erred in law by taking a historical approach to considering the out of scope but relevant evidence about facts of which it was not seized, the Supreme Court Chamber finds no error in the trial chamber's conclusion that it may rely on the evidence outside the temporal or geographic scope of the closing order for the limited purposes of clarifying a given context, establishing by inference the elements of criminal conduct occurring during the material period, or demonstrating a deliberate pattern of conduct. Alleged errors related to the underlying crimes. I will now turn to the findings relevant to the substance of the case against KHIEU SAMPHAN, namely the crimes of which he was convicted, murder as a crime against humanity. The Chamber observes that the trial chamber applied a mens rea standard of dolus eventualis when assessing the facts relevant to the crimes against humanity or murder, as it did in case 002/01, and as this chamber upheld on appeal in that case, KHIEU SAMPHAN argues that this standard was incorrect, claiming it did not exist in customary international law in 1975, and further that such a definition was not foreseeable or accessible to him at that time. The Supreme Court Chamber disagrees and concludes that the trial chamber did not err. KHIEU SAMPHAN asserts that the trial chamber erred in finding that murder as a crime against humanity was established at Trump Cooperatives, Japan Mall Dammed Worksite, First January Dammed Worksite, and Kampong Chnang Airfield Construction Site, based partly on culpable omissions without first finding that there was a duty to act. The Supreme Court Chamber concludes that the trial chamber did not err.
As to whether murder was established at the following sites. Number 1, Trump cooperatives. Khieu Samphon argues that the trial chamber erred, in fact, by finding that there were deaths due to starvation and rudimentary medical care at Trump cooperatives, and erred in finding that the requisite level of intent had been established. The Supreme Court chamber concludes that Khieu Samphon has failed to demonstrate an error on the part of the trial chamber. Trump Topeng Dam worksite. Khieu Samphon argues that the trial chamber erred in assessing whether the authority acted with the requisite level of intent concerning the deaths at Topeng Dam worksite, as there were factors beyond their control that could have led to the conditions causing death at that location. The Supreme Court chamber has analyzed his arguments and the trial chamber's findings and concludes that Khieu Samphon has failed to demonstrate error on the part of the trial chamber. Number 3. First January Dam worksite. Khieu Samphon argues that the trial chamber erred in finding that murders had occurred at the 1st January Dam worksite due to the living and working conditions imposed, including the lack of medicine, and that workers died due to accidents. He also argues that the trial chamber erred in finding that the perpetrators knew there was a lack of sufficient food and medicine, but nevertheless continues to push the workers to complete the work. The Supreme Court chambers concludes that Khieu Samphon has failed to demonstrate error on the part of the trial chamber. 4. Kampong Chnang Airfield Construction Site. Khieu Samphon argues that the trial chamber erred in finding that the deaths due to the conditions imposed were committed with the requisite level of intent because there were factors beyond their control that could have caused the underlying condition causing death at that location. The Supreme Court chamber concludes that Khieu Samphon has failed to demonstrate error on the part of the trial chamber. 5. Phnom Kral Security Center. The trial chamber found that 2 deaths occurred at Phnom Kral Security Center that amount to a murder as a crime against humanity. The first involved an inmate named Hus, who the trial chamber found had been killed by prison guards. The second involved an inmate named Tui, who died as a result of the poor conditions of detention he experienced. Khieu Samphon argues that the trial chamber erred by finding that both of these murders had been established beyond reasonable doubt. The Supreme Court chamber concludes that the trial chamber erred in its finding concerning the deaths of Hus and Tui, as they were clearly based on the written statements of deceased witnesses who Khieu Samphon was unable to confront. Accordingly, we reverse the trial chamber's findings concerning the crime against humanity of murder at Phnom Kral Security Center. Extermination as a crime against humanity. Extermination of the Cham. The trial chamber found that murder as a crime against humanity was established in relation to intentional killings of Cham at the Wat O Trokun Security Center in 1977 and the Trier Village Security Center in 1978. it was unable to establish a definite number of victims, but was certified that a great number of armed civilians were taken to and killed at both security centers. It found that these murders satisfy the requirement of killings on a massive scale and formed part of the same murder operation. The trial chamber determined that the crime against humanity of extermination subsumed that of murder and entered a conviction only for extermination. KHIEU SAMPHAN challenges the sufficiency of the evidence that killings occurred at the village and at Wat Otrakuan. However, the Supreme Court chamber does not consider the trial chamber's findings to be unreasonable. He further challenges whether a numerical threshold for extermination had been met, since the trial chamber was unable to establish a definite number of victims, but the Supreme Court chamber concludes that the facts support the trial chamber's determination that killings on a massive scale occurred. Finally, KHIEU SAMPHAN challenges whether there was intent to kill on a large scale, but the Supreme Court chamber discerns no error in the trial chamber's findings. Extermination of the Vietnamese. KHIEU SAMPHAN alleges multiple factual and legal errors in the trial chamber's findings with respect to the killing of Vietnamese in Svai Rieng, in DK Waters, in Kampong Chhnang province, at Wat Ksach, and in Krache, as well as at all consigned security centers, submitting that the crime against humanity of murder and extermination could not be established in relation to any of these killings. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate that the trial chamber erred in finding that killings occurred at the above-mentioned locations. As to whether they amounted to extermination, the Supreme Court chamber discerns no error in the trial chamber's aggregation of the killings committed in multiple areas due to its finding that they were part of the same murder operation. Enslavement as a crime against humanity. KHIEU SAMPHAN challenges whether enslavement as a crime against humanity occurred at Phnom Krau Security Center, alleging that the trial chamber was only seized of enslavement at one location known as K11 within Phnom Krau Security Center, and that the evidence of enslavement at K11 was insufficient. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate any error on the part of the trial chamber with respect to this issue. Deportation as a crime against humanity. The trial chamber found KHIEU SAMPHAN guilty of the crime against humanity of deportation of the Vietnamese from Tam Kok cooperatives and from Prey Veng province. KHIEU SAMPHAN challenges the chamber's conclusion that the Vietnamese were deported from Tam Kok cooperatives across a national border as well as from Prey Veng. He also challenges the trial chamber's finding that there was an intent to deport the Vietnamese. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate any error on the part of the trial chamber. Torture as a crime against humanity. KHIEU SAMPHAN challenges the sufficiency of the evidence relied upon by the trial chamber to establish the crime against humanity of torture of the Jam at Trier village. The Supreme Court chamber discerns no error on the part of the trial chamber and concludes that KHIEU SAMPHAN has failed to demonstrate that its finding that Jam word of torture was one that no reasonable trier of fact could make. Persecution as a crime against humanity. KHIEU SAMPHAN asserts that under customary international law in 1975, persecution as a crime against humanity required an objective to remove the targeted persons from the community in which they live alongside the perpetrators, or even from human society in itself. In the Case 001 appeal judgment, the Supreme Court chamber addressed this issue and concluded that such an objective was not an element of persecution under customary international law in 1975. KHIEU SAMPHAN, however, argues a departure from our previous ruling, which was based on analysis of post-World War II jurisprudence. This we decline to do. Consequently, KHIEU SAMPHAN has failed to demonstrate error on the part of the trial chamber. KHIEU SAMPHAN also alleges that the trial chamber erred in law by characterizing undifferentiated treatment that has a particular impact on a class of individuals as discrimination in fact. He argues that indirect discrimination is a recent human rights concept that was not considered discrimination in fact in customary international law in 1975. With respect to this claim, the Supreme Court chamber concludes in summary as follows. Political persecution of the Jam. The trial chamber found that the Jam were targeted on political grounds and were dispersed to break up their communities. KHIEU SAMPHAN challenges this finding, claiming that the trial chamber failed to establish that the population transfers affected the Jam exclusively or at least primarily and were therefore discriminatory. Similarly, KHIEU SAMPHAN claims that the evidence fails to establish that in the course of the transfer, the Jam were treated differently from others, which he asserted was the test the trial chamber used in case 002/01 concerning new people, quote unquote. The Supreme Court chamber concludes that KHIEU SAMPHAN has misinterpreted its jurisprudence in case 002/01. It finds that the trial chamber applied the correct legal test to determine whether persecution occurred. KHIEU SAMPHAN also challenges whether the mens rea was properly established by the trial chamber, claiming that there were non-discriminatory grounds for the movement of the Jam. The Supreme Court chamber concludes that his arguments fail to demonstrate that the trial chamber's findings with respect to this issue was unreasonable. KHIEU SAMPHAN further submits that the trial chamber erred in its assessment as to whether the severity of the discriminatory acts amounts to persecution. The Supreme Court chamber concludes that the acts rise to the requisite level of severity to amount to political persecution as a crime against humanity. KHIEU SAMPHAN's arguments concerning political persecution of the JAM are dismissed. Political persecution of other real or perceived enemies, quote unquote. KHIEU SAMPHAN challenges the discernibility of the targeted group of real or perceived enemies of the CPK, quote unquote, in relation to the findings of political persecution at S21 and all consigned security centers. The Supreme Court Chamber addressed this issue in K001 and K002/01 and concluded that political persecution was understood as encompassing situation where the perpetrators designated targeted groups in broad strokes without inquiry into the political views held by the individuals concerned. It, quote, thus confirmed the possibility that persecution as a crime against humanity might target aggregated groups without any common identity or agenda, unquote. Accordingly, the Supreme Court Chamber rejects KHIEU SAMPHAN's argument that, quote, real or perceived enemies of the CPK, unquote, is not a sufficiently discernible group for a finding of political persecution. Political persecution at cooperatives and security centers. Number 1. Trump cooperatives. KHIEU SAMPHAN argues that the evidence was insufficient to find that former Khmer Republic soldiers and officials and new people were persecuted at the Trump cooperatives on political grounds. The Supreme Court Chamber concludes that KHIEU SAMPHAN has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 2. The Pronouncement website. KHIEU SAMPHAN submits that the only acts of persecution in question at the Pronouncement website were the exclusion of new people from leadership positions and their being monitored by base people, which he argues is insufficient to find that any fundamental rights were violated or that the gravity requirements to constitute persecution as a crime against humanity was satisfied. Supreme Court Chamber concludes that KHIEU SAMPHAN has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 3. 1st January dam website. KHIEU SAMPHAN argues that the trial chamber erred in fact by concluding that there was discrimination against people at the 1st January dam website. 2. Erred in law by asserting that there was a fundamental right to equal treatment. And 3. Erred in law and in fact by finding that the treatment violated the fundamental right of new people to equal treatment. And 4. Erred in law by failing to set out the requisite level of gravity that needed to be met for the underlying acts to be characterized as persecution. As explained in the full written judgment, the Supreme Court Chamber concludes that the trial chamber erred in finding that during the relevant time period there was a fundamental right to equal treatment laid down in international customary or treaty law that had been infringed or violated, and accordingly reverses KHIEU SAMPHAN conviction for political persecution against new people at the 1st January dam worksite. KHIEU SAMPHAN also argues that there was insufficient evidence to find that former Republic soldiers and officials were persecuted on political grounds at the 1st January Dam work site. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 4. S21 Security Center. KHIEU SAMPHAN argues that the trial chamber erred in findings that the acts directed at, quote, real or perceived enemies of the CPK, unquote, were discriminatory in fact, and claiming that the massive scale of the arrest show that they were indiscriminate. He argues that in case 001, the Supreme Court chamber reversed the trial chamber's finding on persecution on political grounds, since it found that no discernible criteria were applied in targeting the victims. KHIEU SAMPHAN asserts that the evidence in case 002/02 evinced nothing new that would support a different findings in this case. The Supreme Court chamber concludes that the facts that people were arrested en masse does not preclude a finding of persecution on political grounds as long as members of the targeted group were arrested because they belong to the targeted group. The Supreme Court chamber's reversal of the eviction of persecution on political grounds in case 001 was specific to Duch. KHIEU SAMPHAN has not demonstrated that the trial chamber erred in finding that the acts were discriminatory. 5. Okansang Security Center. KHIEU SAMPHAN claims that the trial chamber erred in finding that political persecution occurred at Okansang Security Center, arguing mainly that the evidence relied on does not show discriminatory treatment. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate error on the part of the trial chamber. Religious persecution. The trial chamber made legal findings with respect to persecution on religious grounds in two sections of the trial judgment. The first specifically in relation to the treatment of the jam at the 1st January Dam worksite, and the second in relation to the treatment of the jam generally. Concerning the 1st January Dam worksite, the trial chamber found that jam workers suffered discrimination because they were forced to eat pork, prevented from worshipping, and prevented from speaking their native language. In relation to the treatment of the jam generally, the trial chamber found that the restrictions and the cultural restrictions were imposed included prohibition on daily prayers, forcing jam to eat pork, forcing jam to wear the same dress and haircuts as the Khmer people, forcing jam to speak only the Khmer language, and burning Qurans and dismantling mosques or causing them for non-religious purposes. It was certified that these restrictions were discriminatory and were deliberately perpetrated with the intent to discriminate against the jam because of their religious and cultural practices. KHIEU SAMPHAN challenges the sufficiency of the evidence that certain persecutory acts occurred at the 1st January Dam worksite and elsewhere in Cambodia. He also argues that the trial chamber erred by failing to consider whether the restriction on freedom of the religion were permissible in law. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate error on the part of the trial chamber with respect to these issues. KHIEU SAMPHAN argues that the persecutory acts did not discriminate because they were applied equally to everyone. The Supreme Court chamber considers that the discrimination in fact can occur when there are unequal consequences for a particular group of an act or omission of general application. The Supreme Court chamber does not discern any error in the trial chamber's conclusion that the JAM were, quote, predominantly and particularly affected, unquote, by the religious and cultural restrictions so as to establish discrimination in fact. KHIEU SAMPHAN argues that the trial chamber erred in finding that there had been a breach of fundamental rights, as none of the religious and cultural restrictions breach any of the rights the trial chamber referred to in its legal finding, noting that the trial chamber did not find that the right to freedom of religion had been breached as regards the treatment of JAM generally, but only at the 1st January dam worksite. The Supreme Court chamber notes that the trial chamber stated that the right to personal dignity was violated by the religious and cultural restriction at issue and considers this finding to be reasonable. Accordingly, the Supreme Court chamber rejects KHIEU SAMPHAN's arguments. KHIEU SAMPHAN also challenges whether there was intent to discriminate on religious grounds. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate error on the part of the trial chamber with respect to this issue. The trial chamber found that the crime against humanity of religious persecution against Buddhists was established at the Tram cooperatives. In particular, it found that over 100 Buddhist monks were deliberately gathered at Ang Roka Pagoda and forced to defrock. It considered that references to monks as, quote, worms, unquote, or, quote, leeches, or, unquote, and announcements dismissing Buddhism as mere superstition and the Buddha as only concrete, quote, unquote, demonstrated the discriminatory intention behind the process. The trial chamber further found that the Buddhist symbols were destroyed and pagodas used for a range of non-religious purposes across Tramkok district. It concluded that the evidence revealed a complete abolition of Buddhist practices constituting an, quote, organized and sustained attack against religion, unquote, which was considered to be incompatible with the implementation of the revolution. Based on these considerations, the trial chamber concluded that the physical and mental impact of these events infringed fundamental rights to a degree of gravity similar to that of other crimes against humanity. KHIEU SAMPHAN submits that the trial chamber erred in finding that the religious persecution had been established, claiming there was a lack of evidence regarding the physical or mental effects of the alleged acts of persecution against Buddhists. Moreover, he asserts that because there was no evidence of discriminatory treatment against Buddhist monks, and Buddhists, they were treated like the rest of the population. The Supreme Court chamber disagrees and concludes that KHIEU SAMPHAN has not demonstrated any error on the part of the trial chamber with respect to these issues.
Racial persecution. The trial chamber found that the crimes against humanity of racial persecution of Vietnamese was established at Trump Cooperatives, S21 Security Center, or Consign Security Center, and in Pre Vang and Svai Rieng. It found that this crime was committed as part of a policy of targeting Vietnamese for adverse treatment throughout the decade period, in particular for deportation before April 1977 and for destruction as a racial group thereafter. Because the Vietnamese were considered to be the DK's most dangerous enemy, KHIEU SAMPHAN challenges whether racial persecution occurred at any of the above-mentioned sites. The Supreme Court chamber concludes that KHIEU SAMPHAN has failed to demonstrate error on the part of the trial chamber. Other inhumane acts as crimes against humanity, KHIEU SAMPHAN challenges whether the trial chamber properly assessed the principle of legality when it found that it was both foreseeable and accessible in general that other inhumane acts were punishable as crimes against humanity by 1975. According to him, it is not enough to say that other inhumane acts were foreseeable, since this category can cover numerous types of behavior. Rather, he asserts that the trial chamber should have identified the behavior at issue and examined whether it could have defined as criminal at the time. The Supreme Court chamber is of the view that KHIEU SAMPHAN misunderstands the application of the principle of legality with regard to other inhumane acts. What is required is that the category of other inhumane acts be foreseeable and accessible to the accused, which the trial chamber found in this case. Consequently, there was no error. KHIEU SAMPHAN also asserts that conduct must breach a specific prohibition set out in human rights instruments to amount to an inhumane act. In case 002/01, the Supreme Court chamber subscribed to the approach taken by the ICTY Kupreskic trial chamber of relating other inhumane acts to conduct infringing basic rights appertaining to human beings as identified under international legal instruments. The Supreme Court chamber explained, however, that it is not required that the particular conduct must be expressly criminalized under international law, as this would render the concepts of other inhumane acts as a residual category unnecessary. KHIEU SAMPHAN's submission in this regard is accordingly dismissed. Enforced disappearances. KHIEU SAMPHAN challenges the trial chamber's findings that conduct characterized as enforced disappearances was established at Tram Cooperatives, Krang Tachan Security Center and Phnom Krao Security Center. For reasons explained more fully in the judgment, the Supreme Court Chamber concludes that the trial chamber properly established that the crime against humanity of other inhuman acts through conduct characterized as enforced disappearances occurred in Tramco and at Krang Tachan and Phnom Krao. Forced marriage. The trial chamber found that the regulation of marriage was one of the CPK's policies designed and implemented to achieve a socialist revolution in Cambodia. This policy involved the commission of the crimes against humanity of other inhuman acts that occurred through conduct characterized by the chamber as forced marriage and rape in the context of forced marriage. The trial chamber thus found KHIEU SAMPHAN guilty of committing these other inhuman acts as crimes against humanity through a joint criminal enterprise. KHIEU SAMPHAN objects to his convictions for these crimes with respect to the regulation of marriage policy, arguing a violation of the principle of legality, disputing factual findings, and challenging the seriousness of the behavior. The co-prosecutors in turn appealed the trial chamber's ruling, which effectively excluded males as victims of forced sexual intercourse in the context of forced marriage and rape in the context of forced marriage. KHIEU SAMPHAN argues that the trial chamber erred in relying on international criminal case law to determine the legality of forced marriage, in allegedly failing to ascertain whether the conduct violated basic rights, in failing to consider the alleged lawfulness of forced marriage under Cambodian and other domestic regimes in 1975-1979, and in allegedly failing to properly consider the principle of a justem generis in assessing the comparative gravity of forced marriage in other conflicts. As explained in the full written judgment, the Supreme Court Chamber rejects all of these arguments. KHIEU SAMPHAN further argues that the trial chamber erred in how it treated rape in the context of forced marriage. The co-prosecutors in turn have appealed what they assert to be errors in the trial chamber's approach with respect to male victims of forced intercourse in the context of forced marriage. Specifically, they cite the trial chamber's findings on the elements of other inhuman acts with regard to conduct charged as rape in the context of forced marriage, arguing that the trial chamber failed to make proper findings with respect to the experience of male victims of this crime. The Supreme Court Chamber concludes that the trial chamber erred in its identification of the element of rape in its analysis. Rather, the chamber should have only considered the charged conduct that had occurred being acts of forced sexual intercourse between male and female victims who had been forcibly married. This chamber further finds that such forced acts violated the basic rights of physical integrity and human dignity applicable in 1975-1979 and are of comparable gravity. We thus conclude that this conduct, properly described as forced sexual intercourse in the context of forced marriage, fell within the scope of crimes against humanity of other inhumane acts. The Supreme Court chamber thus clarifies that the victims of forced sexual intercourse comprise both female and male victims. Pursuant to our analysis, we uphold the co-prosecutor's appeal regarding errors in the trial chamber's approach to male victims. The nature and implementation of the marriage policy. KHIEU SAMPHAN raises various factual challenges to the trial chamber's findings on the purposes of marriage policy, namely population increase and the control of sexual interactions. He also alleges a contradiction between those two goals and asserts that to restrict male-female sexual interactions conflicts with the desire to increase the population. KHIEU SAMPHAN also disputes the trial chamber's finding that the CPK principle of consent to marriage was not applied in a practice, as well as findings about both marriages of disabled soldiers and wedding ceremonies. The Supreme Court chamber rejects all of these arguments for reasons explained in the full written judgment. As also more fully explained in the full written judgment, the Supreme Court chamber similarly rejects KHIEU SAMPHAN's assertion that there was no policy of forced sexual intercourse, as well as his denial that sexual intercourse was compelled. KHIEU SAMPHAN also disputes the trial chamber's findings regarding instructions from the upper echelon to arrange marriages, reports on marriage to the upper echelon, and reports on monitoring the consummation of marriages, as well as his own personal involvement in the regulation of marriage. The Supreme Court chamber concludes that, for the most part, KHIEU SAMPHAN mischaracterizes both the trial chamber, the trial judgment, and the evidence with respect to these matters. His submissions are therefore dismissed. The legal findings on the element of other inhumane acts. The trial chamber found that the conduct charged as forced marriage and the conduct charged as rape in forced marriage had occurred. With regards to forced marriage, it considered that serious mental or physical suffering was inflicted on individuals through the threat of forcing them to marry strangers, and the fear instilled to pressure them to consummate the marriage, and found that the conduct was performed intentionally. The trial chamber was therefore satisfied that conduct characterized as forced marriage was established and met the threshold of other inhumane acts. Please take the accused to the restroom and we will pause momentarily and we will resume the pronouncement of the judgment when he returns. The court is now in session. With regard to the conduct charge as rape in the context of forced marriage, the trial chamber found that rape had occurred with regard to female victims and had caused serious mental or physical suffering or injury. Consequently, in the manner of that it affected female victims, such forced sexual intercourse also constituted an inhumane act. However, with regard to male victims of forced sexual intercourse in the context of forced marriage, the trial chamber concluded that, given the circumstances, they could not be considered rape victims. The trial chamber then considered whether the male victims had experienced another act of sexual violence of comparable gravity. It concluded that while the male victims indeed had experienced sexual violence that had breached their human dignity, there was insufficient evidence concerning the extent of its impact on them. Accordingly, the trial chamber concluded that the elements of other inhumane acts as crimes against humanity were not established with respect to the male victims of forced sexual intercourse in the context of forced marriage. The Supreme Court chamber has reviewed the evidence that was before the trial chamber and concludes that it was in fact sufficient to support the conclusion that male victims experience an impact comparable to that which female victims experience when forced to engage in intercourse in the context of forced marriage. It follows that such forced sexual intercourse also constituted an inhumane act as to the male victims, a factor that we have also considered in upholding the co-prosecutor's appeal regarding the trial chamber's approach to male victims. KHIEU SAMPHAN in turn asserts that the trial chamber erred in the findings it made on the actual seriousness of forced marriage in failing to consider the context of traditional arranged marriages, which he asserts were akin to marriages under the CPK, and in the findings it made on serious mental or physical suffering or injury in the case of various individuals. The Supreme Court chamber rejects each of these assertions. Furthermore, there was no merit to any of KHIEU SAMPHAN's challenges to evidence attesting to individual experiences of harm. KHIEU SAMPHAN raised alternative inferences not supported by the evidence, misrepresented the evidence, mischaracterized the trial judgment, or simply disagreed with the trial chamber's findings without demonstrating any error. KHIEU SAMPHAN next challenges the trial chamber's findings with respect to the female victims of conduct charged as raped in the context of forced marriage. The Supreme Court chamber discerns no error in the findings of the trial chamber in this regard. The co-prosecutors in turn also challenges the trial chamber's findings, but with respect to male victims in the context of conduct charged as raped in the context of forced marriage. The Supreme Court chamber recalls its finding that the trial chamber erred in attempting to identify the elements of rape with the respect to male victims, but instead should have considered only whether the charged conduct of forced sexual intercourse had occurred in the context of forced marriage. Having reviewed the evidence that was before the trial chamber, we conclude that it was sufficient to support the conclusion that the charged conduct of forced sexual intercourse in the context of forced marriage did in fact occur. KHIEU SAMPHAN argues that the trial chamber erred in its findings on harm experienced by a number of female victims, and also alleges error in the failure to consider certain other evidence. This chamber considers both of these arguments to be without merit. Indeed, KHIEU SAMPHAN misrepresents the evidence or merely disagrees with the trial chamber's findings without demonstrating any error. Genocide. The trial chamber found that the Vietnamese constituted a protected racial, national, and ethnic group during the indictment period. After determining that a number of Vietnamese were among the victims of the crimes against humanity of murder and extermination, and that the CPK targeted them because they were Vietnamese with the intent to destroy the group, the trial chamber was satisfied that genocide had been established. KHIEU SAMPHAN contends that the trial chamber erred in concluding that the killings of Vietnamese occurred, or that the killings at O Con Sang, at S21, and in Cambodian territorial waters, including at O Chơ Tia Port, were of members of the protected group. He argues that the trial chamber erred in failing to determine whether there was an intent to destroy the protected group in whole or in part, as well as whether there was an intent to destroy the protected group. The Supreme Court chamber discerns no error in the trial chamber's findings concerning the killing of Vietnamese in Svai Rieng, DK waters, Kampong Chnang province, Wat Ksait, and Krati. The chamber also concludes that the trial chamber accurately set out the applicable law as it relates to genocide. Moreover, in determining that the mens rea of genocide by killing was established, the trial chamber properly relied on factors in addition to the scale of the atrocities, such as the existence of a policy of targeting the Vietnamese for adverse treatment in DK throughout the relevant period. The Supreme Court chamber thus finds no merit in KHIEU SAMPHAN's arguments regarding genocide and rejects them as further explained in the full written judgment.
Alleged errors relating to individual criminal responsibility. KHIEU SAMPHAN's roles and responsibility during the DK period. KHIEU SAMPHAN challenges the trial chamber's findings about his roles and responsibilities during the DK. Many of these findings, combined with other evidence, underpin the trial chamber's finding about his JCE contribution, intent, and knowledge. The Supreme Court chamber has determined that the vast majority of KHIEU SAMPHAN's arguments are unfounded. He merely advances an alternative reading of the facts, one that cherry-picks the evidence and ignores large swaths of relevant evidence and fails to demonstrate that the trial chamber's assessment of the evidence was unreasonable. Grung, Deputy Prime Minister and President of the State Presidium. The Supreme Court chamber upholds the trial chamber's finding that as the Grung Deputy Prime Minister, KHIEU SAMPHAN promoted the CPK's agenda by reading press communiques of an April 1975 Special National Congress and December 1975 Third National Congress. That the trial chamber was unable to determine whether these events actually took place is immaterial to the undisputed facts that KHIEU SAMPHAN read the communiques for radio broadcast and that these promoted to the party line. The Supreme Court chamber dismisses KHIEU SAMPHAN's argument that the trial chamber could not rely on his conduct as president of the State Presidium because this role was largely symbolic, quote-unquote, as he misapprehends the import of the trial chamber's description. It also dismisses KHIEU SAMPHAN's argument that the trial chamber ignored evidence that the CPK mistrusted him. The Supreme Court chamber also rejects his repeated arguments that he could not contribute to the common purpose by exercising diplomatic duties and generally by promoting the CPK party line in his speeches, because he says this was not criminal in and of itself, quote unquote, or he supported only benign activities. The trial chamber's findings amply demonstrate that KHIEU SAMPHAN's speeches promoted a variety of the CPK's criminal policies. While the Supreme Court chamber agrees with KHIEU SAMPHAN that the trial chamber erred by attributing to him a speech at the first session of the People's Representative Assembly, and these errors did not occasion a miscarriage of justice, as they were not indispensable to the trial chamber's corresponding conclusions. Membership in the Central Committee. KHIEU SAMPHAN concedes that he was first an alternate member and then a full member, quote-unquote, of the Central Committee. In his view, the trial chamber erred by 1. Overstating the powers of the Central Committee, 2. Attributing decisions of the Standing Committee to the Central Committee, 3. Conveniently, quote-unquote, dating KHIEU SAMPHAN's admission as a full member of the Central Committee in order to implicate him in the Central Committee decision of the 30th of March 1976, and 4. Finding that he participated in party congresses. The Supreme Court chamber rejects these arguments for the reasons explained in the full written judgment. The Supreme Court chamber accepts his argument that not all telegrams sent to party center reached all the Central Committee's members, but concludes he was well informed by virtue of his membership in Office 870. The Supreme Court chamber has also considered KHIEU SAMPHAN's submissions with respect to 4 decisions of the Central Committee. 1. The May 1972 decision to close markets and the use of money and organized cooperatives in the liberated zones. 2. The mid-1974 decision to close the door to party membership in order to prevent spies from infiltrating the party. 3. The June 1974 decision to undertake the final assault and evacuation of Phnom Penh in the dry season of 1974-1975. And 4. The 30th of March 1976 decision of the Central Committee regarding a number of matters. This chamber finds no error in the trial chamber's findings or in its conclusion that KHIEU SAMPHAN was aware of the first 3 of these decisions, which is solidly grounded in the evidence. The chamber discerns no error in the trial chamber's findings that the Central Committee appointed KHIEU SAMPHAN to the role of President of the State Presidium. We similarly see no reason to disturb the trial chamber's finding that KHIEU SAMPHAN contributed to the common purpose by assenting to the contents of that decision. Moreover, the conclusion of the trial chamber that he did attend the 4th and the 5th party congresses was supported by the evidence. Attendance and participation in meetings of the Standing Committee. The chamber finds no error in the trial chamber's conclusion that KHIEU SAMPHAN's frequent attendance at meetings of the Standing Committee accorded him, quote, a position of unique standing, unquote, within the party. He merely advances an alternative interpretation of the evidence and repeats arguments from cases 002/01 rather, and case 002/02, without demonstrating that the trial chamber's conclusion was unreasonable. KHIEU SAMPHAN's arguments that the trial chamber erred by holding him responsible based on his participation in meetings of the Standing Committee are unfounded. Contrary to his submissions, the trial chamber did not extrapolate from KHIEU SAMPHAN's active participation in 2 meetings that he participated on other occasions or took part in decision-making, and did not hold him responsible on this basis. KHIEU SAMPHAN challenges the trial chamber's finding that he contributed to the common plan by attending Standing Committee meetings discussing Kampong Chhnang airfield. The Supreme Court chamber concludes that the trial chamber erred in finding that he attended the meeting on 9th of October 1975, but this error did not occasion a miscarriage of justice. This chamber finds no error in the trial chamber's characterization of the evidence pertaining to the 2 other meetings discussing Kampong Chhnang airfield. The Supreme Court chamber also finds no error in the trial chamber's reliance inter alia on a statement by the late Ieng Sari to find that KHIEU SAMPHAN attended a meeting of the Standing Committee in September 1975 where, quote, agriculture, drought, and industry, unquote, were discussed. KHIEU SAMPHAN argues that the trial chamber erred by relying on democratic centralism to find that he could have intervened in the Central and Standing Committees meetings. The Supreme Court chamber concludes that the trial chamber did not rely on democratic centralism to hold KHIEU SAMPHAN responsible for Central Committee decisions, but on his full membership in that body. The chamber sees no error in that approach, as the trial chamber did not find that KHIEU SAMPHAN actively participated in standing committee meetings. His submission that he could not intervene in such meetings is moot. Residual functions. KHIEU SAMPHAN challenges the trial chamber's reliance on evidence of Im Eun and Ike Hain to find that he spoke about enemies during political training sessions held at Borei-Kaila K6 and the Khmer Soviet Friendship Institute of Technology K15. The Supreme Court chamber has reviewed the evidence and found no error in the trial chamber assessment. This chamber rejects KHIEU SAMPHAN's submissions that the trial chamber ignored other evidence from witnesses whose account support the conclusion that he was involved in politic training. It dismisses his argument that statements, quote, relating to the CPK's general economic project, unquote, could constitute a significant contribution to the JCE. The Supreme Court chamber dismisses the submission of KHIEU SAMPHAN that the trial chamber erred in finding that he joined that office 870 in October 1975. He repeats arguments rejected by this chamber in case 002/01 and which failed to persuade us that the trial chamber erred. Second, this chamber rejects KHIEU SAMPHAN's assertion that the trial chamber exaggerated the evidence concerning his role in Office 870. KHIEU SAMPHAN disputes the trial chamber's findings about his role in DK trade and commerce. A number of similar challenges were dismissed by this chamber in case 002/01. Since he merely advances an alternative interpretation of the evidence, KHIEU SAMPHAN portrays himself as having played a minor technical role in the Commerce Committee. These submissions are similarly dismissed. The Supreme Court chamber finds no error in the trial chamber's reliance on the evidence of Sorghum Lamut, alias Sorghum Lamut, Yin Kuch, and Biet Buen, alias Bietna. The Supreme Court chamber did not consider it unreasonable that the trial chamber concluded that KHIEU SAMPHAN would have been aware of the contents of two letters sent to him by Amnesty International in 1977 and 1978, in part due to his connection to both the late Ieng Sary and the Ministry of Foreign Affairs. joint criminal enterprise. The trial chamber found that by the 17th of April 1975 and continuing until at least the 6th of January 1979, KHIEU SAMPHAN shared the common purpose of rapidly implementing socialist revolution in Cambodia through a, quote, great leap forward, unquote. According to the trial chamber, this common purpose was criminal because it was intrinsically linked to policies that involved the commission of crimes. These policies were 1. The establishment and operation of cooperatives and work sites. 2. The establishment of and operation of security centers and execution sites. 3. The targeting of specific groups. And 4. The regulation of marriage. The trial chamber further determined that KHIEU SAMPHAN made a significant contribution to the commission of crimes perpetrated by CPK cadres within the scope of K002/02, and that he shared the intent of other senior leaders in a joint criminal enterprise to participate in and commit the crimes encompassed by the common purpose. The trial chamber accordingly found KHIEU SAMPHAN guilty of committing through a JCE genocide, crimes against humanity, and grave breaches of the Geneva Conventions. KHIEU SAMPHAN submits that the trial chamber made several errors of law and fact in defining the common purpose of the senior leaders of DK as criminal. He disputes the application of a criminal label to each of the CPK's policy. He further contends that the trial chamber erred when it found that we both shared the criminal aspect of the common purpose and significantly contributed to it, as well as in finding that he intended to participate in the common purpose and in the crimes underlying it. Some of the legal errors alleged by KHIEU SAMPHAN concerning the trial chamber's statement of the law applicable to JCE. For instance, he submits, among other things, that culpable omission is not sufficient to establish participation in a common purpose, and that the requisite link must be between a JCE member and all direct perpetrators of a crime, and not just one such perpetrator. For reason explained in the full written judgment, the Supreme Court chamber dismisses KHIEU SAMPHAN's assertions in this regard as they fail to demonstrate any appealable error. Criminality of the common purpose. KHIEU SAMPHAN repeatedly objects to how the trial chamber concluded that the CPK's plan for socialist revolution was criminal in nature. The Supreme Court chamber recalls that in order to give rise to criminal liability, the common purpose, that is, the object of the planned action among several persons, must be of a criminal character, in this sense that it either amounted to or involved the commission of a crime. KHIEU SAMPHAN claims that the common purpose of rapidly implementing socialist revolution in Cambodia was not criminal in nature, but rather was a purely political move. That characterization ignores the fact that the underlying plan was to use any means necessary to achieve the socialist revolution in the country, including the crimes that were committed on a massive scale against the Cambodian people throughout the implementation process. The Chamber considers that by no stretch of the imagination could it be seriously stated that the CPK revolution was implemented in a benevolent or altruistic manner. While there may have existed socialist revolutions that have taken place without bloodshed or criminal activity, this was not one of them. KHIEU SAMPHAN claims of error regarding the trial chamber's approach in determining the criminality of the common purpose are accordingly dismissed. KHIEU SAMPHAN further submits that the trial chamber misconceived the CPK's notion of enemies and wrongly established the existence of a policy to eliminate them at security centers and execution sites. He asserts that the trial chamber's error precluded the conclusion that crimes against humanity were committed at the S21, Krang Ta Chan, Okan Sang, and Phnom Krao security centers, and repeatedly asserts that the trial chamber fails to view the evidence in its proper context, namely that of armed hostilities against the Lon Nol regime and subsequently Vietnam. This chamber thoroughly reviewed the evidence with respect to the trial chamber's approach to real and perceived enemies of the CPK and concludes that KHIEU SAMPHAN arguments are without foundation. The errors alleged by him as to the trial chamber's finding regarding the existence and criminality of a policy to establish and operate security center and execution site during the DK era are thus dismissed. With respect to establishing cooperatives and work sites, KHIEU SAMPHAN disputes the trial chamber conclusion that this policy was intrinsically linked to the common purpose and involved the commission of crimes against humanity. He contends inter alia that the trial chamber mischaracterized the CPK's political orientation regarding the cooperatives by selectively reviewing official CPK documents through an incriminating lens of, quote, amity, unquote, and ignoring exculpatory evidence demonstrating that there was a constant concern for the population. While it is not necessary to refer to every piece of evidence on the trial record, the trial chamber did in fact refer to most of the documents to which KHIEU SAMPHAN points, and his alternative interpretations of those documents do not suffice to overcome the trial chamber's conclusions based on its own fair and reasonable interpretation and those same documents. his allegations of error regarding the existence and criminality of a policy to establish and operate cooperatives and worksites during the DK era are thus dismissed. Policy of targeting specific groups and regulating marriage. Turning to policy of targeting specific groups, the Supreme Court Chamber concludes that KHIEU SAMPHAN has not demonstrated that the trial chamber erred in finding that the policy broadly targeted Buddhists, Cham, Vietnamese, and former Khmer Republic soldiers and officials for the reasons explained in the full written judgment. As to the policy of regulating marriage, KHIEU SAMPHAN submits that it was not possible to find this existence of a criminal policy regarding the organization of forced marriage and the commission of rape in this context. For reasons explained in the full written judgment, the Supreme Court Chambers has rejected his assertions, his allegations of error in the findings regarding the existence and criminality of a policy to regulate marriage during the DK era are thus dismissed. KHIEU SAMPHAN's contribution. The two remaining essential JCE issues relate to KHIEU SAMPHAN's contribution to and intent to participate in the common criminal purpose. He submits that the trial chamber wrongly found that his support for and participation in and or contribution to the political process for the purpose of implementing a socialist revolution in Cambodia were sufficient to establish his significant contribution to the commission of any crimes such purpose may have involved. The Supreme Court Chamber recalls that the contribution to a JCE may take many forms, and as previously determined by the Chamber, quote, even activities that are on their face unrelated to the commission of crimes may be taken into account when determining whether the accused made a significant contribution thereto, unquote. The Supreme Court Chamber accordingly rejects KHIEU SAMPHAN's argument that the trial chamber could not take into account his activities that were on their face directed at implementing a socialist revolution as opposed to the commission of specific crimes when determining that he made a significant contribution to furthering the JCE common criminal purpose. The Supreme Court Chamber similarly rejects KHIEU SAMPHAN's submission that the trial chamber essentially imposed on him a form of collective responsibility, quote unquote, or guilt by association, claiming that the trial judgment clearly shows that it based its conclusions about his significant contribution to the JCE on his own conduct or acts as opposed to those of others. KHIEU SAMPHAN's allegations of error regarding his significant contribution to the JCE's common criminal purpose are thus dismissed. KHIEU SAMPHAN's knowledge and intent as to whether he knew of and intended the commission of the crimes underlying the encompassed by the common purpose, KHIEU SAMPHAN disputes the trial chamber finding that he did and reiterates that the common purpose was not criminal. KHIEU SAMPHAN does not deny that he and the other members of the enterprise shared a common intent of transforming Cambodia into a self-sufficient, classless agricultural society through a socialist revolution, but he continues to assert that they never intended to commit crimes individually or as a group, and that their common purpose was benign and for the benefit of the population of Cambodia. He argues that any crimes that might have occurred in the process of implementing the common purpose were extraneous thereto and happened without his knowledge and participation. A review of the trial judgments shows that the trial chamber fully examined and applied the mens rea requirement of the JCE for each of the crimes alleged. Moreover, it conducted this exercise in relation to KHIEU SAMPHAN's imputed knowledge as a senior leader and active participant at the heart of the CPK, and his close relationship with those at the highest level of its leadership. Contrary to his assertion that the trial chamber improperly imposed a, quote, vicarious criminal liability, unquote, on him, the Supreme Court chamber finds that the trial chamber inferred his intent from his own acts and conduct. The Supreme Court chamber observes that in concluding that KHIEU SAMPHAN had the requisite mens rea under JCE, the trial chamber clearly concluded that he had direct contemporaneous knowledge of the commission of crimes and shared the intent for their commission with other JCE members. The several errors that KHIEU SAMPHAN alleged with respect to the trial chamber's findings regarding his contemporaneous knowledge and shared intent to commit crimes at cooperatives and worksites, at security centers, and against specific groups, namely the Cham, Buddhist, Vietnamese, and former Khmer Republic officials, are dismissed for reasons explained in the full written judgment. The Supreme Court chamber similarly rejects KHIEU SAMPHAN's assertion that the trial chamber erred in concluding that he knew of and intended to commit crimes in regulating marriage. The Supreme Court chamber has addressed in the full written judgment KHIEU SAMPHAN's arguments in support of these contentions. For the most part, they simply constitute alternative interpretation of the evidence. KHIEU SAMPHAN's assertion of error are thus dismissed. Applicability of JCE liability to crimes committed with Douglas eventualists. As a final JCE-related matter, the Supreme Court chamber has determined proprio motu that the trial chamber erred in its application of the law relating to JCE liability for crimes committed with dolus eventualis. Although none of the parties advanced this issue on appeal, the Supreme Court chamber considers it necessary to address, as it is of general significance to the ECCC's jurisprudence. The trial chamber determined, quote, that the degree of intent required under JCE1 is direct intent, unquote, and that, quote, indirect intent or dolus eventualis. Again, the trial chamber determined, quote, that the degree of intent required under JCE1 is direct intent, unquote, and that, quote, indirect intent dolus eventualis does not suffice for a finding of JCE before the ECC, unquote. As a result, the trial chamber concluded that a crime against humanity of murder committed with dolus eventualis fell outside the common purpose of the JCE and accordingly analyzed KHIEU SAMPHAN's responsibility for this crime under the mode of liability of aiding and abetting instead. The Supreme Court chamber concludes that the trial chamber erred when it failed to apply our holding in K002/01 that an accused may be held liable for crimes that are not directly intended but are nevertheless encompassed within a JCE common purpose. In this respect, the Supreme Court chamber recalls its finding in K002/01 that liability under JCE for crimes that fell outside the common purpose, that is JCE 3, was not part of customary international law in 1975, and that liability under JCE before the ECCC could therefore only arise for crimes falling within the common purpose. The trial chamber incorrectly concluded that if the commission of a crime is merely foreseeable, that crime automatically falls outside the common purpose. This ignores situations where the probable commission of a crime was jointly and willingly agreed upon or accepted by all JCE participants. In such situations, as the JCE participants share an agreement regarding the commission of a crime with dolus eventualis in furtherance of the common purpose, the crime is encompassed by the common purpose. The trial chamber's error led it to determine that murders committed with dolus eventualis at the following location fell outside the JCE common purpose: the Tramcock Cooperatives, the 1st January Dam Worksite, the Trapang Mall Dam Worksite, the Kampong Chnang Airfield Construction Site, the S21 Security Center, the Krang Tachan Security Center, and the Phnom Kraul Security Center. The trial chamber determined that KHIEU SAMPHAN was instead culpable for aiding and abetting those murder with dolus eventualis. For reasons explained in the full written judgment, the Supreme Court chamber finds that a crime against humanity of murder with dolus eventualis at these locations was encompassed by the JCE's common purpose, and that KHIEU SAMPHAN made a significant contribution thereto with the shared intent to commit this crime while being aware of the substantial likelihood of deaths. Phnom Kraul Security Center is excluded from this analysis because as previously discussed, the Supreme Court chamber reversed the trial chamber finding that the crimes against humanity of murder was established with respect to that location. The Supreme Court chamber accordingly recharacterizes the form of liability from aiding and abetting to JCE for the crime against humanity of murder with Doldus eventualists at the Tramkok Cooperatives, 1st January Damburg site, Ropiang Mall Damburg site, Kampong Chnang Airfield Construction Site, S21 Security Center, and Krang Tajan Security Center. It therefore will not consider KHIEU SAMPHAN's remaining challenges related to aiding and abetting.
Sentencing. The Supreme Court chamber recalls that KHIEU SAMPHAN currently serves a life sentence, the maximum sentence permitted at the ECCC, which was imposed by the trial chamber in case 002/01 and upheld by the Supreme Court chamber on appeal. Case 002/01 and 002/02 were prosecuted separately but originated from a single indictment that was severed in the interest of trial management and in light of the frail health and advanced age of all the accused. Although the two cases are thus related, they deal with different facts that were adjudicated in two trials that produced separate dispositions, each of which requires the imposition of a separate sentence after a finding of guilt. For this reason, the trial chamber sentenced KHIEU SAMPHAN to life imprisonment for the crimes of which he was convicted in case 002/02, and we affirmed that sentence. The Supreme Court chamber considers the life sentence that was imposed in case 002/02 to be appropriate in light of all the circumstances, including the tragic nature of the underlying events and the extent of harm caused by KHIEU SAMPHAN. In the circumstances, however, in addition to affirming the life sentence in this case, we affirm the decision of the trial chamber to have the sentence run concurrently with the one imposed in case 002/01 as permitted by Article 138 of the Cambodian Criminal Code. Nonetheless, KHIEU SAMPHAN has raised several challenges to the fairness of the sentence imposed by the trial chamber in case 002/02. He argues that the trial chamber erred in describing the primary objective of sentencing, that it erred in its assessment of the gravity of the crimes by including in its analysis a crime for which he was not charged, that it erred in its assessment of aggravating factors, including the double counting of his positions of authority and influence as an aggravating factor as to the gravity of the crimes, and finally, that it erred in assessing mitigating factors. The Supreme Court chamber has thoroughly considered each of these assertions and considers them without merit. The sole exception is the claim that the trial chamber erred in both assessing the gravity of the crimes committed by including a crime of which KHIEU SAMPHAN was not charged, and impermissibly double counting his position of authority and influence. Although the Supreme Court chamber decides that doing so constituted error, it also concludes that in the circumstance of this case, their consideration does not render the ultimate sentence inappropriate or unfair in any way. Dispositioned. For the foregoing reasons, the Supreme Court chamber, pursuant to Article 4.1b of the ECCC Agreement, Articles 14 new 1b and 36 new of the ECCC Law and Internal Rule 111, noting the respective written submissions of the parties on appeal and their arguments presented at the hearing from 16 to 19 August 2021, grants in part and dismisses in part KHIEU SAMPHAN's appeal, and therefore, insofar as it relates to facts of death that occurred at Tramkok Cooperative's Trapengtmo Dam worksite, 1st January Dam worksite, Kampong Chnang Airfield Construction Site, S21 Security Center, and Krang Tachan Security Center, reverses KHIEU SAMPHAN's conviction for aiding and abetting the crime against humanity of murder with dolus eventualis and recategorizing the facts, enters a conviction for the crime against humanity of murder with dolus eventualis through a joint criminal enterprise, insofar as it relates to facts of death that occurred at Phnom Krau Security Center. Reverses KHIEU SAMPHAN's conviction for the crime against humanity of murder at Phnom Krau Security Center, insofar as it relates to facts of persecution at 1st January Dam worksite, reverses KHIEU SAMPHAN's conviction for the crime against humanity of persecution on political grounds of new people at the 1st January Dam worksite, insofar as it relates to facts of killing of the charm that occurred at Tri Village and Wat O Trokun, and killings of the Vietnamese in Svai Rieng, in DK Waters, in Kampong Chnang Province, at Wat Ksach and in Krati, as well as at O Konsai Security Center, affirms KHIEU SAMPHAN's conviction for the crimes against humanity of extermination, insofar as they relate to facts of forced labor of prisoners at Phnom Krau Security Center, affirms KHIEU SAMPHAN's conviction for the crime against humanity of enslavement. Insofar as they relate to facts of removal of the Vietnamese from Tram Kok district and from Prevang province, affirms KHIEU SAMPHAN's conviction for the crimes against humanity of deportation of Vietnamese. Insofar as they relate to the facts of physical and mental mistreatment of the Cham at Trier village, affirms KHIEU SAMPHAN's conviction for the crime against humanity of torture. Insofar as they relate to the facts of the treatment of the Cham and of real or perceived enemies of the CPK, including former Khmer Republic soldiers and officials, and new people at Tram cooperatives, dropping them worksite, first gender them worksite, not in relation to new people, Kampong Chnang Airfield Construction Site, S21 Security Center, Krang Tachan Security Center, or Konsai Security Center and Phnom Krao Security Center, affirms Khieu Samphan's conviction for the crimes against humanity of persecution on political grounds. Insofar as they relate to facts of discrimination against the Cham, affirms Khieu Samphan's conviction for the crimes against humanity of persecution on religious grounds. Insofar as they relate to facts of discrimination against Buddhist and Buddhist monks, affirms Khieu Samphan's conviction for the crimes against humanity of persecution on religious grounds. Insofar as they relate to facts of discrimination of the Vietnamese at Tram cooperatives, S21 Security Center, or Konsai Security Center, and in Prevang and Svay Rieng provinces, affirms Khieu Samphan's conviction for the crimes against humanity of persecution on racial grounds. Insofar as they relate to facts of disappearances at Tram cooperatives, Krang Tachan Security Center and Phnom Krao Security Center, affirms Khieu Samphan's conviction for the crimes against humanity of other inhumane acts through conduct characterized as enforced disappearances. Insofar as they relate to facts of forcible transfers of the Cham, insofar as they relate to facts of forcible transfer of the Cham in the course of the movement of population phase 2, affirms Khieu Samphan's conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced transfer. Insofar as they relate to facts of forced marriage and forced sexual intercourse in the context of forced marriage, within the context of the nationwide regulation of marriage, affirms Khieu Samphan's conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced marriage and rape, and additionally categorized as crime against humanity of other inhumane acts in the form of sexual violence, understood to constitute forced sexual intercourse in the context of forced marriage with regards to female victims, grants the co-prosecutor's appeal, and enters a conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced marriage, and additionally categorized as crime against humanity of other inhumane acts in the form of sexual violence, understood or to constitute forced sexual intercourse in the context of forced marriage with regard to male victims. Insofar as they relate to willful killing, torture, inhuman treatment, willfully causing great suffering or serious injury to body or health, willfully depriving prisoners of war or civilians the rights of fair and regular trial, and the unlawful confinement of civilians, affirms Khieu Samphan's conviction for grave breaches of the Geneva Conventions. Insofar as they relate to the facts of killings of the Vietnamese, affirms Khieu Samphan's conviction for the crimes of genocide. affirms KHIEU SAMPHAN's sentence of life imprisonment in case 002/02, which shall run concurrently with the life sentence imposed in case 002/01. Orders that KHIEU SAMPHAN remained in the custody of the ECCC pending the issuance of the full written appeal judgment and the finalization of arrangements for his transfer in accordance with the law to the prison where he will continue to serve his sentence. 60 officers, please take the accused back to his cell. The chamber declares the closure of the pronouncement. All rise.
bóng giờ cỡ xa lắm không.
Alo, bạn ấy mua là đây, mua lại đã video mà. Alo, video ăn miếng này, chăm tị.
Dương sầm lệ ấy dương cho ban ấy nha. Cái kia trăm năm rồi. Ok, tôi tìm ai đó một bạn dụ rong tới hay nên này ông ca đã chi tiết nên tôi xong sẽ sai về mình tinh trên nít nít ai đó một bạn dụ rong tới bạn chơi mà đón hái ai xong chơi nhà này chơi khách mà khăn nít đó ông khách làm bài làm chơi em nói là cái quạt trôi thôi chứ quạt line đây mình ba đó tí chơi chứ con muốn chơi
Petra ខ្ញុំថាឲ្យគាត់មុនល្អជាងអីមិនមើលមកព្រោះឲ្យខ្ញុំមុនវាអត់សន្សំទេព្រោះគេភ្ញៀវ
បាទឥឡូវនេះសង្សិទ្ធសាព័ត៌មានរបស់យើងនឹងចាប់ផ្ដើមហើយជាបឋមគឺសូមគោរពឯកឧបនាយករដ្ឋមន្ត្រីសូមគោរពលោក Stephen Machas តំណាងអង្គការសហជីវជាតិដែលអញ្ជើញចូលរួមជាអធិបតីនៅក្នុងការប្រកាសសាលដីកាស្ថាពរលើសំណុំរឿង002/02ហើយអង្គបញ្ញមិញនេះបានបិទបញ្ចប់ហើយអញ្ចឹងជាការថ្លែងការណ៍របស់តំណាងរាជរដ្ឋាភិបាលកម្ពុជានិងអង្គការសហជីវជាតិជាដំបូងខ្ញុំបាទសូមអញ្ជើញលោក Stephen Machas សូមអញ្ជើញថ្លែងការណ៍ទៅកាន់អ្នកសារព័ត៌មាន I would like to invite Mr. Stephen Machas please address to the media. Yes.
Good afternoon. The pronouncement of the appeal judgment today in case 002/02 is a significant achievement in the work of the extraordinary chambers in the courts of Cambodia. This case... Excuse me.
Hello. ការប្រកាសសាលដីកាលើបណ្ដឹងសារទុកក្នុងសំណុំរឿង002/02នៅថ្ងៃនេះគឺជាសមិទ្ធផលមួយដ៏ធំធេងនៅក្នុងការងាររបស់អង្គចំណុចជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអពតក
This case has addressed some of the most serious international crimes, and this appeal judgment will certainly have an important impact on the further development of international criminal law.
សំណុំរឿងនេះបានឆ្លើយតបទៅនឹងអកតកម្មធ្ងន់ធ្ងរបំផុតជាអន្តរជាតិមួយចំនួនហើយសាលដីកាលើបណ្ដឹងសារទុកនេះពិតជានឹងមានអនុភាពយ៉ាងសំខាន់ទៅលើការអភិវឌ្ឍបន្ថែមទៀតនៃច្បាប់ព្រហ្មទណ្ឌអន្តរជាតិ
This case is also noteworthy for the scope and breadth of the crimes charged. The trial judgment in case 002/02 was the longest issued by the ECCC, and the Supreme Court chamber considered more than 1,800 grounds of appeal. សំណុំរឿងនេះក៏មានសារៈសំខាន់ផងដែរចំពោះវិសាលភាពនិងទំហំនៃអក្រិតកម្មដែលត្រូវបានចោទប្រកាន់សាលក្រមក្នុងសំណុំរឿង002/02ជាសាលក្រមវិញជាងគេដែលចែងដោយអវតកហើយអង្គជំនុំជម្រះតុលាការកំពូលបានពិចារណាលើមូលដ្ឋានជាង 1,800 នៃបណ្ដឹងសារទុក The ECCC has once again demonstrated its capacity to conduct judicial proceedings in accordance with international standards.
ជាថ្មីម្ដងទៀតអវតកបានបង្ហាញនៅសមត្ថភាពរបស់ខ្លួនក្នុងការរៀបចំកិច្ចដំណើរការនីតិវិធីផ្លូវតុលាការអនុលោមតាមបទដ្ឋានអន្តរជាតិ
This is a historic achievement for the ECCC and for international criminal justice more broadly. This judgment marks the final judgment at the ECCC and the completion of the judicial cases before the ECCC.
នេះជាព្រឹត្តិការណ៍ជាប្រវត្តិសាស្ត្រសម្រាប់អវតកនិងយុត្តិធម៌ព្រហ្មទណ្ឌអន្តរជាតិកាន់តែទូលំទូលាយថែមទៀតសាលដីកានេះគឺជាសាលដីកាចុងក្រោយនៅអវតកនិងការបិទបញ្ចប់សំណុំរឿងនានាតាមផ្លូវតុលាការនៅអវតក
The Secretary General of the United Nations has consistently underscored that there must be no impunity for the most serious international crimes.
លោកអគ្គលេខាធិការអង្គការសហប្រជាជាតិបានគប់បញ្ជាក់ជាបន្តបន្ទាប់ថាមិនត្រូវឲ្យមានអំពើនិទានភាពចំពោះក្រតកម្មធ្ងន់ធ្ងរបំផុតជាអន្តរជាតិទៀតទេ
The delivery of today's judgment reflects the long-standing commitment on the part of the United Nations, the government of Cambodia, and the international community to guarantee justice for the Cambodian people for the horrific crimes committed during the Khmer Rouge regime.
ការប្រកាសសាលដីកានៅថ្ងៃនេះឆ្លុះបញ្ចាំងនូវការបដិញ្ញាចិត្តជាយូរអង្វែងរបស់អង្គការសហប្រជាជាតិរាជរដ្ឋាភិបាលកម្ពុជានិងសហគមន៍អន្តរជាតិក្នុងការធានាឲ្យមានយុត្តិធម៌ជូនដល់ប្រជាជនកម្ពុជាចំពោះក្រតកម្មដ៏រន្ធត់ដែលបានប្រព្រឹត្តក្នុងអំឡុងរបបខ្មែរក្រហម
The delivery of today's judgment highlights that the international community is ready and willing to ensure accountability for the most serious international crimes even for crimes committed decades ago.
ការប្រកាសសាលដីកានៅថ្ងៃនេះគូបញ្ជាក់ថាសហគមន៍អន្តរជាតិត្រៀមខ្លួនរួចជាស្រេចនិងមានឆន្ទៈក្នុងការធានាឲ្យមានការទទួលខុសត្រូវចំពោះក្រតកម្មធ្ងន់ធ្ងរបំផុតជាអន្តរជាតិទោះបីបានប្រព្រឹត្តទៅច្រើនទសវត្សរ៍មកហើយក្តី
Yesterday I met with Deputy Prime Minister Bin Chin, with whom I had a most constructive discussion about the residual work of the ECCC and the commitment of the United Nations to ensure an enduring legacy of the ECCC for the people of Cambodia.
កាលពីថ្ងៃម្សិលមិញខ្ញុំបានជួបពិភាក្សាប្រកបដោយការស្ថាបនាជាមួយឯកឧត្តមឧបនាយករដ្ឋមន្ត្រីប៊ិនឈិនអំពីការងារសេសសល់របស់អបតកនិងការបដិញ្ញាចិត្តរបស់អង្គការសហប្រជាជាតិក្នុងការធានារក្សានៅកេរដំណែលជាយូរអង្វែងរបស់អបតកសម្រាប់ប្រជាជនកម្ពុជា
The residual functions are key to ensuring the investment of the international community in the ECCC and in anchoring and preserving the court's legacy in Cambodia.
មុខងារសេសសល់គឺជាកិច្ចការគន្លឹះដើម្បីធានាឲ្យមានការវិនិយោគពីសហគមន៍អន្តរជាតិចំពោះអបតកក្នុងការដាក់បង្ហាញនិងថែរក្សាកេរដំណែលរបស់តុលាការនេះនៅកម្ពុជា
Finally, I want to take this opportunity to thank the judges and the staff of the ECCC for their commitment and dedication to the ECCC. And I want to urge the international community to continue to support the ECCC during its residual phase.
ឆ្លៀតក្នុងឱកាសនេះខ្ញុំសូមថ្លែងអំណរគុណដល់លោកស្រីចៅក្រមនិងបុគ្គលិករបស់អបតកចំពោះការបដិញ្ញាចិត្តនិងការខិតខំប្រឹងប្រែងអស់ពីកម្លាំងកាយចិត្តរបស់ខ្លួនក្នុងការបំពេញការងារដើម្បីអបតកនិងសូមជំរុញដល់សហគមន៍អន្តរជាតិមេត្តាបន្តឧបត្ថម្ភគាំទ្រដល់អបតកក្នុងដំណាក់កាលការងារសេសសល់របស់តុលាការនេះ
បាទខ្ញុំបាទសូមថ្លែងអំណរគុណចំពោះលោក Stephen Machas តំណាងអង្គការសហប្រជាជាតិដែលបានធ្វើសេចក្តីថ្លែងការណ៍ជាបន្ទាប់ទៅនេះខ្ញុំបាទសូមគោរពអញ្ជើញឯកឧត្តមឧបនាយករដ្ឋមន្ត្រីប្រចាំការឯកឧត្តមប៊ុនឈិនក៏ជាប្រធានក្រុមការងាររបស់រាជរដ្ឋាភិបាលទទួលបន្ទុកសាលាក្តីខ្មែរក្រហមសូមគោរពអញ្ជើញឯកឧត្តមថ្លែងការណ៍ទៅកាន់សារព័ត៌មានបាទសូមគោរពអញ្ជើញ
ដោយឯកឧត្តមលោកស្រីបានស្ដាប់ហើយថ្ងៃនេះអង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីកាសង្ខេបក្នុងសំណុំរឿង002ដំណាក់កាលទី2ពាក់ព័ន្ធនឹងខៀវសំផនដែលជាសំណុំរឿងចុងក្រោយហើយខ្ញុំឯកភាពនឹងអ្វីដែលឯកឧត្តមឧបការីតំណាងឲ្យឯកឧត្តមអគ្គលេខាធិការអង្គការសហប្រជាជាតិលោកលើកកំបាញ់មិញហើយសូមឯកភាពគ្រប់គ្រងអ្វីដែលឯកឧត្តមបានលើកកំបាញ់មិញនេះ
Today, the Supreme Court Chamber of the Extraordinary Chambers in the Courts of Cambodia has pronounced a summary of the appeal judgment in case 002/2 against KHIEU SAMPHAN, and this is the last case. And I share and agree with what Excellency Assistant Secretary General has just mentioned.
ការប្រកាសសាលដីកាព្រឹកមិញនេះคล้ายជាថ្ងៃបិទទំព័រដ៏ខ្មៅងងឹតសម្រាប់ប្រជាជនកម្ពុជាយើងដែលទន្ទឹងរង់ចាំយូរមកហើយនិងសម្រាប់មនុស្សជាតិទាំងមូលពាក់ព័ន្ធទៅនឹងដំណើរការស្វែងរកយុត្តិធម៌នៅក្នុងក្របខ័ណ្ឌនៃអប្រតិកម្មព្រហ្មទណ្ឌជាតិនិងអន្តរជាតិ
The pronouncement of the judgment this morning is the day to close the dark chapter for our Cambodian people and the whole humanity who have been long waiting for the process of seeking justice within the framework of national and international criminal crimes.
ចាប់តាំងពីរបបកម្ពុជាប្រជាធិបតេយ្យហៅកាត់ថាខ្មែររបបខ្មែរក្រហមត្រូវបានព្រួលរំលំនៅថ្ងៃទី7 ខែមករាឆ្នាំ79មកកម្ពុជាមានការបដិញ្ញាចិត្តខ្ពស់ក្នុងការស្វែងរកយុត្តិធម៌ដល់ជនរងគ្រោះទាំងអស់ដើម្បីបញ្ចប់វប្បធម៌និទានភាពចំពោះអក្រកម្មដែលបានប្រព្រឹត្តនៅក្នុងរបប3ឆ្នាំ8ខែនិង20ថ្ងៃដែលធ្វើឲ្យប្រជាជនយើងរាប់លាននាក់បាត់បង់ជីវិត
Since Democratic Cambodia regime, in short, the Khmer Rouge regime, was overthrown on 7th of January 1979, Cambodia has strong commitment to seeking justice for all victims, to end the culture of impunity for the crimes committed in the regime that lasted for 3 years, 8 months, and 20 days, and took millions of our people's lives.
រាជរដ្ឋាភិបាលកម្ពុជាក្រោមការដឹកនាំដ៏ជ្រាលជ្រៅបំផុតរបស់សម្ដេចអគ្គមហាសេនាបតីតេជោហ៊ុនសែននាយករដ្ឋមន្ត្រីនៃប្រជាណាចក្រកម្ពុជាបានព្រួយផ្ដើមបង្កើតអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអវតកឬហៅកាត់តាសាលាក្តីខ្មែរក្រហមដោយបានអញ្ជើញអង្គការសហប្រជាជាតិឲ្យចូលរួមដើម្បីវិនិច្ឆ័យនៅអក្រិតកម្មសម្លាប់បង្គាលរួមមានអក្រិតកម្មប្រឆាំងមនុស្សជាតិនិងប្រល័យពូជសាសន៍ដែលប៉ះពាល់ដល់សង្គមជាតិនិងមនុស្សជាតិទាំងមូល
The royal government of Cambodia, under the wise leadership of Samdech Aket Mahasenapati Techo Hun Sen, Prime Minister of the Kingdom of Cambodia, initiated the establishment of the Extraordinary Chamber in the Courts of Cambodia, or the Khmer Rouge Tribunal, by having invited the United Nations to partake in the trial of the massacre, crimes against humanity, and genocide that have repercussions on society and humanity as a whole.
ការផ្ដល់យុត្តិធម៌ដល់ជនរងគ្រោះបានចូលរួមដល់ការពង្រឹងសន្តិភាពស្ថិរភាពនិងការបង្រួបបង្រួមជាតិព្រមទាំងធានាកុំឲ្យមានសោកនាដកម្មបែបនេះកើតឡើងសាជាថ្មីនៅទីនេះឬនៅទីណាទាំងអស់នៅក្នុងពិភពលោកយើងនេះ
Justice that delivered to the victims has contributed to the strengthening of peace, stability, and national unity, and ensuring the prevention of such tragedy here in Cambodia or elsewhere in the world.
ជាង16ឆ្នាំរហូតមកពេលនេះអវតកបានបញ្ចប់ជាស្ថាពរចំពោះសំណុំរឿងទាំងអស់ចំនួន7របស់ខ្លួនរួចហើយ
From early 2006 until now, the ECCC has concluded all judicial proceedings of its 7 case files.
គ្រប់សំណុំរឿងទាំងអស់បានដំណើរការជំរះក្តីអនុលោមទៅតាមនីតិវិធីតុលាការដែលក្នុងកំឡុងពេលនោះគ្រប់ភាគីតុលាការទាំងអស់ត្រូវបានអនុញ្ញាតឲ្យប្រើប្រាស់សិទ្ធិនិងកាតព្វកិច្ចរបស់ខ្លួនយ៉ាងពេញលេញទៅតាមនីតិវិធីត្រឹមត្រូវតាមច្បាប់
All the cases have been tried in accordance with the judicial procedures, during which all parties to the cases were allowed to fully exercise their rights and obligation in accordance with the due process of law.
រក្សាបាននៅឯករាជ្យភាពរបស់តុលាការព្រមទាំងជៀសវាងបាននៅការជ្រៀតជ្រែកពីភាគីខាងក្រៅណាមួយ
And they managed to maintain judicial independence and to avoid any external parties' interference.
នេះគឺជាមោទនភាពនិងជាសមិទ្ធផលដ៏ថ្លៃថ្លាបើប្រៀបធៀបទៅនឹងការកាត់សេចក្តីរបស់ខ្មែរក្រហមដែលខូខើគ្មានយុត្តិធម៌និងអមនុស្សធម៌ហើយមិនដែលទទួលស្គាល់នៅសិទ្ធិមូលដ្ឋានរបស់បុគ្គលនោះទេ
These are immense pride and glorious achievements as opposed to the brutal, unjust, and inhumane treatment of the Khmer Rouge regime, which never recognized the fundamental rights of individuals.
ក្រៅពីសមិទ្ធផលផ្នែកយុត្តិធម៌ខាងលើអវតកក៏កំពុងសម្រេចបាននៅសមិទ្ធផលមិនមែនយុត្តិធម៌ជាច្រើននិងបន្សល់ទុកនៅកេរដំណែលដ៏ល្អនៅក្នុងសង្គមជាតិដូចជា
Besides the aforementioned jurisdictional achievements, the ECCC has also made many other non-jurisdictional achievements and left a good legacy in society, namely
ទី1កេរដំណែលរបស់វត្តកគឺត្រូវបានចាត់ទុកជាកត្តាដ៏សំខាន់បំផុតដែលគួរថែរក្សាទុកនិងផ្ដល់ទុកឲ្យសម្រាប់មនុស្សជំនាន់ក្រោយសម្រាប់ធ្វើការស្វែងយល់ចងចាំនិងទប់ស្កាត់ការវិលត្រឡប់នៃរបបប្រល័យពូជសាសន៍បែបនេះកើតឡើងជាថ្មីម្ដងទៀតតាមរយៈការអប់រំផ្សព្វផ្សាយទូលំទូលាយដល់យុវជនជំនាន់ក្រោយ
Number 1, the ECCC legacy is considered the most important assets that should be preserved for the next generation to learn from, remember, and prevent the recurrence of such a genocidal regime through broad outreach and education for the young generation.
ទី2 អវតកបានរួមចំណែកដល់ការរក្សាបាននៅសុខសុវត្ថិភាពនិងការផ្សះផ្សាជាតិនៅតាមមូលដ្ឋានបានជួយពង្រឹងដល់នីតិរដ្ឋនិងបញ្ចប់នីតិរដ្ឋភាពនៅកម្ពុជា
Number 2, the ECC has contributed to the maintenance of safety and security and national reconciliation at grassroots level, strengthening the rule of law and the ending of impunity in Cambodia.
ទី3អវតកបានក្លាយជាទីកន្លែងមួយសម្រាប់ផ្ទេរចំណេះដឹងចំណេះធ្វើនិងបទពិសោធន៍របស់ខ្លួនទៅដល់ចៅក្រមព្រះអាជ្ញាមន្ត្រីច្បាប់និងមេធាវីជាស្ដែងទស្សនៈទានអំពីរដ្ឋបាលតុលាការបានរបស់អវតកត្រូវបានយកមកបង្កើតនិងដាក់ឲ្យអនុវត្តនៅក្នុងប្រព័ន្ធតុលាការជាតិ
And number 3, the ECCC has become a hub of transferring knowledge, know-how, and experience to judges, prosecutors, legal officials, and lawyers. Manifestly, the concept of the ECC's judicial administration has been adopted and put in place in the national judicial system.
ទី4អវតកត្រូវបានទទួលស្គាល់ជាអន្តរជាតិថាជាតុលាការកូនកាត់គំរូមួយសម្រាប់ធ្វើការវិនិច្ឆ័យនៅអក្រិតកម្មនិងការសម្លាប់រង្គាលនិងក៏បានក្លាយទៅជាតុលាការគំរូបណ្ដាដែលប្រទេសមួយចំនួនបានយកទៅគិតគូរធ្វើជាគំរូក្នុងការបង្កើតតុលាការប្រហាក់ប្រហែលគ្នាក្នុងក្របខ័ណ្ឌស្វែងរកសន្តិភាពក្រោយចម្បាំងឬចំនួនផ្ទៃក្នុង
Number 4, the ECCC is internationally recognized as a model hybrid court for the prosecution of crimes and massacres and has gradually become a model court that several countries consider creating in a similar fashion in the context of seeking for peace after the post-war or internal conflicts.
ឯតំណាងអគ្គលេខាធិការអង្គការសហជាតិជោគជ័យបវតកត្រូវបានចាត់ទុកជាជោគជ័យរួមទាំងអស់គ្នាមានប្រជាជនខ្មែរទាំងមូលរាជរដ្ឋាភិបាលកម្ពុជាអង្គការសហប្រជាជាតិនិងសហគមន៍អន្តរជាតិហើយក៏បីត្រូវបានលើកកម្ពស់ដើម្បីក្លាយជាគំរូតុលាការមួយសម្រាប់ធ្វើការវិនិច្ឆ័យទោសចំពោះអក្រិតកម្មធ្ងន់ធ្ងរនិងការសម្លាប់រង្គាលនាពេលអនាគតនៅលើឆាកអន្តរជាតិនិងជាពិសេសនៅថ្នាក់តំបន់ដើម្បីចូលរួមពង្រឹងប្រព័ន្ធច្បាប់និងយុត្តិធម៌ទណ្ឌកម្មនិងព្រហ្មទណ្ឌអន្តរជាតិ
Excellency Representative of Secretary General, the success of the ECCC is considered the success for all Cambodian people, the royal government, the United Nations, and the international community, and should be promoted in order that it becomes a model court to prosecute serious crimes and massacre in the future on the international stage, and especially at the regional level for the purpose of contributing to the strengthening of the system of international criminal justice.
ខ្ញុំសូមឆ្លៀតយកឱកាសនេះសម្ដែងនៅការកោតសរសើរយ៉ាងជ្រាលជ្រៅជូនចំពោះអ្នកទាំងឡាយដែលបានចូលរួមចំណែកក្នុងដំណើរការនេះរួមមានចៅក្រមព្រះអាជ្ញាមេធាវីមន្ត្រីច្បាប់និងមន្ត្រីបុគ្គលិករដ្ឋបាលតុលាការទាំងអស់ទាំងខាងភាគីជាតិនិងអន្តរជាតិព្រមទាំងប្រជាជននិងបណ្ដារដ្ឋាភិបាលនានាដែលបានប្រោសថវិកាពោលគឺមិត្តរបស់សាលាក្តីជាពិសេសខ្ញុំសូមកោតសរសើរនិងថ្លែងអំណរគុណដល់ជនរងគ្រោះដែលបានតាំងខ្លួនជាដើមបណ្ដឹងរដ្ឋបវេណីនិងផ្ដល់សក្ខីកម្មអំពីរឿងរ៉ាវផ្ទាល់ខ្លួនដ៏ជូរចត់នៅចំពោះមុខតុលាការដើម្បីស្វែងរកការពិតនិងយុត្តិធម៌ដល់ជនរងគ្រោះទាំងអស់នៃរបបដ៏ឃោរឃៅខ្មែរក្រហម
Taking this opportunity, I would like to highly commend those participating in this process, namely judges, prosecutors, lawyers, legal officials, and all court administrative personnel, both the international and national sides of the ECCC, as well as the peoples and the governments, that is the friends of the ECC for funding it. In particular, I wish to admire and thank the victims who have applied to be civil parties for giving testimonies of their bitter personal story before the ECC in order to seek truth and justice for all victims of the brutal Khmer Rouge regime.
ខ្ញុំក៏សូមថ្លែងអំណរគុណនិងកោតសរសើរដល់ភាគីអង្គការសហប្រជាជាតិដែលថ្ងៃនេះអាដាមជាឧបការីបានអញ្ជើញមកហើយដែលបានខ្នះខ្នែងជួយដំណើរការសាលាក្តីខ្មែរក្រហមតាំងពីការកសាងច្បាប់រហូតដល់ពេលនេះដោយបានបញ្ជូនបេសកជនសំខាន់មកពិភាក្សាជាមួយរដ្ឋាភិបាលកម្ពុជា
Taking this opportunity, I would also like to extend my appreciation and admiration to the United Nations, and today we have the presence of Excellency Assistant Secretary General here with us for striving to assist the Khmer Rouge tribunal process from the legislation enactment thus far by dispatching eminent envoys to discuss with the royal government of Cambodia.
ថ្ងៃនេះគឺជាសក្ខីកម្មជាក់ស្ដែងមួយទៀតនៅពេលប្រកាសនេះឯកឧត្តមតំណាងឯកឧត្តមអគ្គលេខាធិការអង្គការសហជីវជាតិបានមកចូលរួមស្ដាប់នៅការប្រកាសសាលដីកាដែលធ្វើឲ្យបរិយាកាសនៅពេលនេះមានភាពអធិកអធមក្រៃលែង
And today it is another testament that we have the representative of Excellency Secretary General of the United Nations here with us, and he is here to attend the pronouncement of the case 002/2 judgment, which makes this event now even more solemn.
ខ្ញុំក៏សូមថ្លែងអំណរគុណយ៉ាងជ្រាលជ្រៅបំផុតចំពោះសម្ដេចអគ្គមហាសេនាបតីតេជោហ៊ុនសែននាយករដ្ឋមន្ត្រីនៃប្រជាណាចក្រកម្ពុជាដែលតែងតែយកចិត្តទុកដាក់គាំទ្រដល់រាល់ដំណើរការទាំងឡាយរបស់សាលាក្តីខ្មែរក្រហមចាប់តាំងពីគំនិតផ្ដួចផ្ដើមក្នុងការបង្កើតតុលាការនិងបន្តគាំទ្រទាំងផ្នែកថវិកានិងសម្ភារៈដល់អវតកដែលបានបញ្ចប់ទាំងស្រុងនៅដំណើរការកាត់ក្តីប្រកបដោយភាពរលូននិងមានការទទួលស្គាល់ជាអន្តរជាតិក្នុងបបផែននៃការចងចាំប្រវត្តិសាស្ត្រក៏ដូចជាការពង្រឹងនិងថែរក្សាសន្តិភាពការបង្រួបបង្រួមជាតិការផ្សះផ្សាជាតិនិងការអភិវឌ្ឍសង្គមកម្ពុជាឲ្យបានរឹងមាំស្ថិតស្ថេរជាយូរអង្វែងសម្រាប់មនុស្សរាប់ជំនាន់ទៅមុខទៀត
I would like to express my deepest gratitude to Samdech Aket Mahasenapati Techo Hun Sen, Prime Minister of the Kingdom of Cambodia, for his continuing support of the Khmer Rouge Tribunal since its inception, and of financial contribution and in-kind assistance to the ECCC, allowing it to conclude all proceedings smoothly with international recognition in the course of historic remembrance, as well as strengthening and mending peace, national unity, national reconciliation, and the robust long-term development of Cambodian society for generations to come.
នៅក្នុងឱកាសដ៏មហាប្រសើរនេះដែរខ្ញុំក៏សូមរំលឹកផងនៅស្នាដៃនិងកេរដំណែលរបស់សម្ដេចវិបុលបញ្ញាសុខអានដែលបានដឹកនាំការចរចាជាមួយភាគីអង្គការសហប្រជាជាតិក្នុងការបង្កើតឲ្យមានតុលាការមួយនេះ
On this very auspicious day, I also wish to recall the accomplishments and legacy of Samdech Vibol Panya Sok-an, who led the team to negotiate with the UN side for establishing this ECCC.
ខ្ញុំក៏បានចងចាំមិនភ្លេចផងដែរនៅពេលដែលខ្ញុំបានត្រូវពិគ្រោះយោបល់លើធម្មនុញ្ញភាពនៃសេចក្តីព្រាងច្បាប់ស្តីពីការបង្កើតអវតកក្នុងនាមខ្ញុំនៅពេលនោះជាប្រធានក្រុមប្រឹក្សាធម្មនុញ្ញផងដែរ
Never will I forget the time when we were jointly consulted to discuss about the constitutionality of the draft law on the ECCC establishment in my capacity as the chairman of the Constitutional Council at the time.
ក្រោយពីដំណើរការកាត់សេចក្តីបញ្ចប់ក្នុងឆ្នាំ2000នេះរាជរដ្ឋាភិបាលកម្ពុជានិងអង្គការសហប្រជាជាតិបានយល់ព្រមលើកិច្ចព្រមព្រៀងបន្ថែមស្តីពីការរៀបចំក្នុងពេលអន្តរកាលនិងការបញ្ចប់ការងាររបស់អង្គជំនុំជម្រះវិសាមញ្ញ នឹងបានចូលជាធរមានកាលពីថ្ងៃទី22ខែធ្នូឆ្នាំ2021
Following the conclusion of the judicial proceedings scheduled for the end of 2022, the Royal Government of Cambodia and the United Nations have agreed on the addendum to the agreement on the transitional arrangements and the completion of the work of the extraordinary chambers, which entered into force on the 22nd of December 2021.
កិច្ចព្រមព្រៀងបន្ថែមនេះតម្រូវឲ្យអវតកបន្តអនុវត្តមុខងារសេសសល់ក្រោយតុលាការរបស់ខ្លួនសម្រាប់រយៈពេល3ឆ្នាំបន្ថែមគឺពីឆ្នាំ2023ដល់ឆ្នាំ2025
This addendum requires the ECCC to continue to perform the residual functions for 3 years from 2023 to 2025.
មុខងារសេសសល់ក្រោយតុលាការគឺរួមមានការងារកតេយុត្តមួយចំនួនរួមទាំងការគ្រប់គ្រងនិងការផ្សព្វផ្សាយបណ្ណាសារស្ដីពីសំណុំរឿងរបស់អវតកឲ្យបានទូលំទូលាយ
The residual functions comprise a number of legal functions, including the management and wide dissemination of information on archives concerning the ECCC case files.
ការងារធំមួយផ្នែកទៀតគឺផ្ដោតទៅលើការអប់រំនិងការផ្សព្វផ្សាយស្ដីពីសមិទ្ធផលនិងកេរដំណែលរបស់អវតកនិងការពិនិត្យតាមដានការអនុវត្តសំណងដែលមានលក្ខណៈផ្លូវចិត្តនិងសមូហភាពដែលដើមបណ្ដឹងរដ្ឋាភិបាលនេះបានសម្រេចផ្ដល់ឲ្យដោយអវតក
Another important aspect of its work focuses on education and dissemination of information on the achievements and legacy of the ECCC and monitoring of the enforcement of moral and collective reparation awarded to civil parties by the ECCC.
ការងារនេះមានសារៈសំខាន់ក្នុងការធានាថាជនរងគ្រោះនៃរបបខ្មែរក្រហមមិនត្រូវបានគេបំភ្លេចចោលក្រោយពេលបញ្ចប់អាណត្តិការងាររបស់អវតកនោះទេ
This work is important to ensure that the victims of the Khmer Rouge regime are not forgotten after the conclusion of the ECCC mandate.
នៅក្នុងអំឡុងពេលអនុវត្តមុខងារសេសសល់រយៈពេល3ឆ្នាំខាងលើគម្រោងមួយចំនួននឹងត្រូវបង្កើតឡើងពាក់ព័ន្ធទៅនឹងការងារអប់រំនិងការគាំទ្រដល់ជនរងគ្រោះក្នុងគោលដៅរំលឹកការចងចាំដើម្បីទប់ស្កាត់និងការវិលត្រឡប់នៃរបបសាហាវយង់ឃ្នងបែបនេះទៀត
During the performance of the aforesaid 3-year residual function, a number of projects in relation to victim education and support are to be developed with the aim of recalling remembrance and the prevention of the recurrence of such a vicious regime.
ខ្ញុំក៏សូមថ្លែងអំណរគុណដល់មិត្តសាលាក្តីដែរដែលពេលនេះមានឯកឧត្តមឯករដ្ឋទូតមួយចំនួនបានជួយចូលរួមហើយតាមរយៈឯកឧត្តមតំណាងឯកឧត្តមអគ្គលេខាធិការម្សិលមិញគឺទូតអាល្លឺម៉ង់លោកបានជួយដូចជា$50,000សម្រាប់បាទ$75,000សម្រាប់រយៈពេល3ឆ្នាំនេះសូមថ្លែងអំណរគុណហើយប្រហែលជាឯកឧត្តមលោកជំទាវជាអគ្គរដ្ឋទូតផ្សេងទៀតជាមិត្តរបស់សាលាក្តីនឹងជួយជើងជើងបន្ថែមទៀត
And today we have the presence of the friends of the tribunal. And also, I would like to extend my appreciation to friends of the tribunal and also please convey my appreciation to Excellency Secretary General as well, Excellency Assistant Secretary General. And I know that yesterday Germany has pledged and promised $750,000 for a period of 3 months on the residual 3 years rather, on the residual function. And I invite and encourage friends of the tribunal to provide the assistance and support further to ECCC.
នៅទីបញ្ចប់ខ្ញុំសូមជម្រាបជូនដល់អ្នកដែលបានរស់រានជីវិតពីរបបប្រល័យពូជសាសន៍កម្ពុជាប្រជាធិបតេយ្យថាថ្ងៃនេះប្រជាជនកម្ពុជានិងពិភពលោកទាំងមូលសូមរំលឹកចងចាំដល់អ្នកដែលបានចែកឋានទៅព្រមទាំងអ្នកដែលបានរងគ្រោះដោយសារអក្រិតកម្មរបបប្រល័យពូជសាសន៍នេះ
To conclude, I would like to inform the survivors of democratic Cambodia that today the Cambodian people and the whole world are commemorating those who passed away and have suffered from the crimes during the regime.
យើងខ្ញុំទាំងអស់គ្នាជឿជាក់ថាការជំនុំជម្រះក្តីគ្រប់សំណុំរឿងទាំងអស់របស់អវតករួមទាំងការចេញសាលដីកាសំណុំរឿង002ដំណាក់កាលទី2នាពេលនេះពិតជាអាចចែករំលែកការឈឺចាប់និងទុក្ខវេទនារបស់អស់លោកអ្នកអស់លោកស្រីបានខ្លះជាក់ជាពុំខាន
We all believe that the trials of all the ECCC case files, including the delivery of the K002/02 appeal judgment now, may share some of your pain and suffering.
សូមថ្លែងអរគុណអាយដាមនៃឧបការីអាយដាមកលេខាធិការអាយដាមលោកជំទាវជាអាយការដ្ឋទូតជាមិត្តរបស់សាលាក្តីទាំងអស់ដែលបានជួយចូលរួមប្រិយមិត្តទាំងអស់ដែលបានជួយចូលរួមសូមសំប្រកបតែពុទ្ធពរទាំងឡាយ4ប្រការអាយុវណ្ណៈសុខៈពលៈ8គ្រាទៀតឡើយ
And again, taking this opportunity, I would like to extend my appreciation to Excellency Assistant Secretary General, Excellency Ambassador to the Kingdom of Cambodia, Excellency, ladies and gentlemen, friends of the ECC, and also colleagues for your presence here today. And I wish you for germs of Buddha blessing, longevity, nobility, good health and strength.
បាទសូមគោរពថ្លែងអំណរគុណអាយដាមឧបនាយករដ្ឋមន្ត្រីក៏ដូចជាអាយដាមឧបការីអគ្គលេខាធិការអង្គការសហប្រជាជាតិដែលបានផ្ដល់នៅសេចក្តីថ្លែងការណ៍ជុំវិញលទ្ធផលនៃការប្រកាសសាលដីកាលើមិនដឹងសារទុកក្នុងសំណុំរឿង002/02ខ្ញុំបាទសូមបិទបញ្ចប់នៅសន្និសីទសារព័ត៌មានរបស់យើងនៅត្រឹមនេះហើយសូមជម្រាបជូនដល់អ្នកសារព័ត៌មានដែរថាបន្ទាប់ពីនេះគឺសន្និសីទសារព័ត៌មានរបស់ភាគីគឺពីសហព្រះអាជ្ញាពីមេធាវីការពារក្តីឲ្យលោកខៀវសំផននិងសហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីនឹងធ្វើនៅខាងក្នុងសាលសវនាការធំដូច្នេះចប់ពីនេះទៅសូមអញ្ជើញអ្នកសារព័ត៌មានទាំងអស់ទៅរៀបចំកាមេរ៉ាហើយនឹងមីក្រូសម្រាប់ការចូលរួមសន្និសីទកាសែតនៅរយៈពេល10នាទីខាងមុខទៀតបាទសូមអរគុណខ្ញុំបាទសូមគោរពថ្លែងអំណរគុណ
photo session ជាមួយ ambassador
Hello, testing. Testing. 1, 2, 3. Test. Yung Lin. Không khó đó. Tao vào đấy Lin. Test. 1, 2, 3.
Okay.
Testing.
Losing business.
Can you hear me? Maybe just.
Lin ơi. Chào bạn. អញ្ចឹងឯងសូមបងប្អូននៅក្នុងសាលនេះបាទសូមត្រៀមបងនៅលើខាង booth គឺយើងខ្ញុំនឹងចាប់ផ្ដើមនៅពេលបន្តិចទៀតហើយដោយសារតែ
We will begin shortly, but we are now trying to sort out some technical issues, so please be with us.
ត្រៀមបច្ចេកទេសយកទាំងអស់វិញឯងបងគ្រាន់ចង់សារមើលមុខបងយ៉ាងម៉េចទេលឿនឡើងហេវបាយម៉ោង1ហើយបានទេណូក៏ឲ្យដាច់នៅលើណាបានអូខេតាបងប្អូនសូមត្រៀម
My greeting to national and international press and journalists. we are going to have a press conference by parties to the case. And we will begin with the office of the co-prosecutors of the ECCC. And without further ado, I'd like to invite Madame Chia Liang, the National Co-Prosecutor, and Mr. Fergal Tanner, the reserved International Co-Prosecutor. To come to the front and to make impression on the judgment by the SCCC in case 002/02 against KHIEU SAMPHAN, the former head of the State of the Presidium of the Democratic Cambodia regime. So I'd like now to hand the floor to the co-prosecutors. The floor is yours. Good afternoon, and I'd like to welcome national and international journalists and the media who are here. This is an auspicious day for the victims. And this is, though, a summary pronouncement of a judgment, and this is a final judgment which is not subject to any further appeal. And I hope that all of you have listened to the pronouncement of the judgment against the appeals by all parties, including the co-prosecutors, the civil parties, as well as the accused lawyer. But for the co-prosecutors, we only appealed against one point regarding the understanding of the trial chamber on one fact, that is the sexual violence against the male victim during the regime. That's the only points that we appealed against. As for the conviction of life imprisonment, we did not appeal against that decision, because to me the judgment by the trial chamber is comprehensive. So in the interest of time, I'd like to open the floor to national and international journalists if you have any point in relation to the judgment that we have heard this morning, and I try to respond to your questions. And my international co-prosecutor, who just replaced another international co-prosecutor in our office, but he is also a former OCP staff that is our office, so he is in greater knowledge about the ongoing at our office. So let me give a floor to him, and then we can open the floor for questions. The floor is your international co-prosecutor.
Thank you very much, Madam Liang. Good afternoon, ladies and gentlemen. I'll read a short statement, and then I'll be happy to answer any questions that any of you might have. Today, the Supreme Court Chambers judges upheld a range of findings made by the trial judges about the depth and extent of the crimes committed by the Khmer Rouge from 1975 to 1979. The leaders of the Communist Party of Cambodia, including KHIEU SAMPHAN, prohibited the practice of all religions, emptied Cambodian cities and towns, and enslaved its people, abolished money and markets, and forcibly collectivized the population. It attempted to break traditional family bonds, forcing strangers to marry and consummate their union under threat of reprisal. The regime summarily executed tens, if not hundreds of thousands of innocent citizens. in a misguided effort to create an agrarian utopia. It put millions to work on ill-conceived rice growing and irrigation projects. Most were underfed and denied proper medical help, and hundreds of thousands died from the inevitable malnutrition and exhaustion. The scale of these crimes was immeasurably vast. In the face of such crimes, no court could bring full justice to all victims, nor hold accountable all those responsible. But thanks to the efforts of so many Cambodians and their international colleagues, who diligently worked to assist judges and to represent the defense, the prosecution, and civil parties for so many years, there was a measure of justice for the millions who suffered and died at the hands of the Khmer Rouge. On this historic day, we acknowledge the courage of the hundreds of witnesses and civil party victims who came forward to provide evidence to this court. In doing so, many had to relive events that caused them immense pain and suffering. We particularly acknowledge the survivors of sexual violence, who, by agreeing to give evidence, had to revisit ordeals that had seriously violated their own dignity. Without their courage, the judges of this court would have been deprived of evidence that has proved essential in establishing the truth concerning the crimes committed by the Khmer Rouge. We are grateful to all Cambodians for their participation in the proceedings, over 230,000 of whom came to this court in person to follow proceedings from this public gallery. We acknowledge today the efforts of many Cambodians and foreigners who worked tirelessly both before and during the lifetime of this court to locate, preserve, and analyze thousands of prisoner lists, meeting records, internal communications, publications, and photographs created by the Khmer Rouge authorities themselves. Those contemporaneous records were cited and relied upon by all parties. They were a source of evidence of incalculable value on which this court could safely rely in its efforts to uncover the truth about the organized, deliberate, and systematic crimes of the Khmer Rouge leadership. That contemporaneous evidence produced by the regime is an insurmountable barrier to those who might one day seek to play down the scale and systematic nature of the crimes. Today's judgment and the other judgments in this case and in its predecessors, cases 2-1 and case 1, will forever stand as a bulwark against revisionism. This court has made an immeasurable contribution to the global effort to combat impunity for mass atrocity crimes. It has strengthened respect for the rule of law in Cambodia, and it has helped to heal the wounds of the past, allowing the people of this country to look to the future. It has reinforced the principle that those responsible for atrocities cannot evade justice forever, and they will be held accountable. Thank you, and I would be happy to take your questions.
Thank you, International Co-Prosecutor. Now I'd like to open the floor to journalists. If you have questions for the prosecutors. My name is Chi from Jodo, Japan. I have a question to the co-prosecutors regarding the forced marriage during the DK regime. Do you have any specific figure? For example, how many couples who were forced to marry? I mean, the total number of forced marriages from 75 to 79. Thank you. And the second question is this. The co-prosecutors actually filed additional appeal regarding the male victims of sexual violence. So my question is, how many cases involved the male victims so that you decided to appeal against the decision of the trial chamber? Also, I have a question for the international co-prosecutor, whether is there any similar cases in the international setting where the victims of sexual violence are male? Thank you. Thank you, Mr. Puiki. Now, I give the floor to the co-prosecutors.
Thank you very much for your questions. Getting evidence of forced marriage during the regime was difficult. There are a range of cultural factors which make it difficult for victims of forced marriage to voluntarily come forward and to give evidence about the circumstances of forced marriage that they were forced into during the period. Those cultural barriers have proved to be difficult to surmount in terms of finding an exact figure or even an approximate figure of the number of women and men who were, number one, forced to marry during the Khmer Rouge period and who suffered as a result of their forced marriages. So we don't have a total number of forced marriages which took place during the Khmer Rouge years. Specifically, you asked about victims of sexual violence, people who were forced to consummate their marriage, who were men. No, we do not have an exact figure for the cultural barriers that I described earlier. We don't pretend that we have reflected the full breadth of this crime. What we have tried to do is reflect a reasonably representative sample, which gives an indication of how systematic and widespread the practice of forced marriage was. You asked for, in the international setting, during the post-election violence in Kenya over a decade ago, there were acts of castration and forced mutilation of men. And there has been litigation at the International Criminal Court concerning the extent to which those crimes against men are crimes of sexual violence. Apart from that, generally, in wartime, the majority of victims are women, and therefore most efforts in other courts have focused on crimes in terms of sexual violence crimes against women.
Thank you. And the National Co-Prosecutor, please. I also would like to comment on your first question. Regarding the facts in this case, usually we observe the sexual violence against women, but at the Khmer Rouge Tribunal we consider all the facts, and these facts are obtained through the testimony of victims, the male victims who were forced to have a sexual intercourse with the women so that they can produce the children for Angkar. And this is called sexual violence through rape in the context of forced marriage. And this happened in Cambodia. Although usually the emphasis was on the women, but this is based on the testimonies of male victims that we obtained. So they are the victims of the regime. So that is my emphasis. On the exact figure, we don't have it. For example, whether there are 50 or 60 couples, no, we don't have that exact figure. But we have the testimonies of those who are the male victims of the regime. As for the life imprisonment, this is the maximum of the conviction that is called can ask for, but we just want to have the correction on the law regarding the male victim. Thank you. Any other question to the prosecutors? Naren, please. Thank you, the co-prosecutors and Mr. Petra. My name is Naren from Kosan Tepip newspaper. To links to the previous questions, I'd like to answer some questions. This morning we have listened to the pronouncement of the judgment by the President of the Court on the upholding of the life imprisonment. And there is another statement that Mr. KHIEU SAMPHAN remained at the ECC's compound until the fully reasoned judgment is issued. So I have two questions regarding this statement. When will the transfer be conducted to the local prison, and if so, which prison? Second question. For the transfer of KHIEU SAMPHAN to the national prison, will he be placed in a separate or isolated room or building, or he's going to be mixed with other local prisoners? Thank you. Thank you. Indeed, we have heard the decision of the Supreme Court this morning. For the prosecutor or co-prosecutors, we are the one who enforce the sentence by the court. Usually after a person is found guilty, the person is convicted and the person becomes a convict. And this tribunal is not a permanent court. This means that today's pronouncement is a summary judgment. So it means that a fully reasoned judgment is not yet rendered. And this means that we have to wait until such fully rendered judgment is published, then he will be transferred out of this tribunal. Second point, regarding which prison that he will be transferred to. Me and my international counterpart actually visited the prison in Kondal province, but we have not yet made a decision. We see which prison would be appropriate for him due to his fragile health state and his advanced age. KHIEU SAMPHAN is 91 years old. So his health condition is different, and it means that we and my international counterpart will need to visit the prisons again and see which one is appropriate to accommodate KHIEU SAMPHAN. Thank you. Thank you. We have 5 more minutes, so the floor is still opened. I have a question. My name is Sanaren from VOA. And my question may go to Mr. Petra or co-prosecutors. The question is, why Mr. KHIEU SAMPHAN is not afforded a right to respond to the pronouncement or judgment, or whether he waived that right? I think people will be interested in this point, and yes, I think you caught that point on time. Today's pronouncement is a decision, not a proceeding to put the question back and forth anymore. Even in the domestic court, they cannot actually be allowed to speak during such a rendition of the judgment. During the proceedings, yes, parties have the right to speak, but during the pronouncement of a final judgment in this regard, the parties are not allowed to speak. This is not limited only to KHIEU SAMPHAN, but to all parties according to the law. Thank you, Madam Co-Prosecutor. This means that this is a final judgment, not subject to further appeal. Any other question? One more question. And after that, we will have the representatives from the defense team for KHIEU SAMPHAN. My name is Saint Thai from VOD. And my question is to Madam Chia Liang. Regarding this final judgment, where Mr. KHIEU SAMPHAN will be sent to serve his sentence, can you tell us when the judgment will come into effect? Regarding when the final judgment is published, this is beyond my reach. It is up to the Supreme Court chamber as when it is going to be ready. Thank you to Madam Chia Liang, and thank you, Mr. International Co-Prosecutor, for joining this press conference after the pronouncement of the final judgment in case 002/02 against KHIEU SAMPHAN. Since there are no more questions and our time is up, I'd like once again to thank the national and international co-prosecutors. And actually, Madam National Co-Prosecutor requests 2 additional minutes for the statement, and the floor is yours. Thank you, and I think that this is the final moment for the court. And as a national co-prosecutor, first and foremost, I'd like to express my thanks to the United Nations and the Royal Government of Cambodia, led by Samdech Maha Sanabade Techo, the Prime Minister, and through Samdech Panyavibol Sok-an for the establishment of the Khmer Rouge Tribunal to assist the victims of the Khmer Rouge regime. Through such collaboration, we see the establishment of this court. These are the important people, the founders of the court. It's a long, windy process before the court can be finally established. But in the end, we succeed in providing justice to the victims. Although the pronouncement of the final judgment this morning is a summary judgment which is subject to no further appeal, we can see the extent of the crimes covered under the judgment. And before such crimes, no court can provide a complete justice to all victims. And not everyone who is responsible would be adjudicated before the court. However, with the effort of the national and international colleagues and staff who tries to work and to contribute to the achievement of the court, to assist the judges, including the civil parties for so many years, we are able to provide justice to the victims and to those who lost their souls during the Khmer Rouge regime. This is a historical day, and we recognize the bravery of the victims, the witnesses, and the civil parties who came out to testify before the court. In so doing, many of them have to relive the events that actually put them into great pain. In particular, those survivors from sexual violence. They had to relive the event, the pain, and the rape, which violated their dignity. Without such bravery, the judges of this court would not be able to have sufficient evidence to prove the truth and the facts related to the crimes committed by the Khmer Rouge. we would like to extend our thanks to all Cambodian people for contributing and participating to these proceedings. Over 230,000 Cambodians actually came to this court in person to follow the proceedings. And today we also acknowledge the effort by everyone, including national and international personnel, for your tireless effort before and during the court proceedings, so that they are able to identify the crime sites, the victims, including various communications, publications, and photos collected by the Khmer themselves. These contemporaneous records were used by all parties, and they are the source of valuable evidence for the court proceedings. These records to be used safely by the court in its endeavor to try to find the truth in relation to the crimes intentionally and systematically committed by the Khmer Rouge leadership. This court contribute to the international effort to fight against impunity in relation to the vicious crimes, and those who are responsible for those crimes will need to answer for their crimes, regardless of how long ago they were committed. This is also going to strengthen the state of law in Cambodia and to heal the pain people suffered in the past, so that we can move forward positively. This is a statement that I need to make to our national and international audience for the collaboration and effort made by everyone at the ECCC. In the interest of time, I'd like to ask for your kind understanding. So again, allow me to say thank you to national and international co-prosecutors for attending this press conference. And after we will have a defense team for KHIEU SAMPHAN to join in the press conference. Thank you.
Rồi sắp xong chương khang tầm nàng mê tùy vì cả việc ở đấy hay xong chương lục tiêu còn ai chương được hàng cái nào và làm bây dương bờ to sau là bờ to săn sắt xa bò miền tham tiết và xong ở cùng bà dương bàn sắp đặt mình hỏi từ we have listened this morning that the Supreme Court chamber actually affirms the life imprisonment of Mr. KHIEU SAMPHAN by the trial chamber, and that the sentence shall be run concurrently with the life imprisonment in case 002/01. And in the judgment by the trial chamber, that is both in 002/01 and 002/02, there is a sentence of life imprisonment in each.
But now the decision is to have it done, to have it run concurrently. And now we have the presence of Mr. KHIEU SAMPHAN, the National Defense Council for KHIEU SAMPHAN, and Ms. Anta Gise, the International Council. And you two have the time to express your observation of the pronouncement of the judgment this morning. The time is yours. Thank you. Regarding the defense position, I think because this is a final judgment by the final court, we have nothing else to do but to accept that final judgment. There is no further appeal at this stage, unless we have extraordinary evidence to appeal to this judgment. So that is my observation. Second, regarding where he would be transferred to, or which prison the co-prosecutors would select for him to serve his sentence. This is something that we would follow, so that we can ensure that the prison is in accordance to the international standard. And for the pronouncement of judgment this morning, as we all have heard, the President of the court declared that this final judgment is not yet in effect. This is something that I'd like to remind everybody why the judgment is not yet enforceable. It's because we do not have a fully reasoned judgment yet. And that is stated by the President of the court himself this morning. And this is consistent with what we have appealed in the past, that we need to wait for a fully reasoned judgment before it is announced, so that immediately it can come into effect. But now the decisions in the judgment cannot be used because it is now simply information. It is not enforceable because it is not a full judgment, even if it is a final judgment by the Supreme Court chamber. So to me, this is against our constitution that states the final judgment of the Supreme Court is not subject to further appeal and is enforceable. But at this point in time, it is not yet enforceable because it is not full. So this means that the judges need to finalize their judgment, and then it will be it shall be pronounced in public. But I don't think that is going to happen. Thank you, Mr. KHIEU SAMPHAN, and the floor is to Ms. Anta Gise.
Hello to all of you. May I speak French? Yes. Well, today we are facing an appeal judgment, a final judgment, and after almost 10 years working on this case, and having worked a lot on law, and necessarily there's disappointment regarding certain points that seem to us to be important, and at the same time we have to accept a decision that once again is definite, and we can no longer appeal, and the chamber of the Supreme Court chamber in its majority dismissed our arguments. So as a defense lawyer of KHIEU SAMPHAN, of course, we feel disappointed that our legal grounds had not been accepted, and there's also this feeling that we are always in a rather strange symbolic fight. When I started this case, there were 3 defendants, and now there's only KHIEU SAMPHAN, was much older, in fact. in his wheelchair, and he was alone before the bench. And it's true that there's still this feeling, always this feeling that we are facing the judgment of one person, and then especially of a regime. So history has been tried, and I think it's a pity that maybe the arguments regarding the exact role of the defendant were not heard in their totality. So we didn't come here with a prepared statement. I think this is also, in terms of symbols, it's important. You saw, and I partook in and I followed the co-prosecutors who came with a prepared statement, which also shows that there was there was no surprise with regard to this decision, which is difficult to comment on today because, as my colleague said, we do not have the totality we do not have all of the grounds. So as a jurist and as a member of a defense term that raised a certain number of legal points, knowing which argument was followed and to dismiss it, it would be important to understand. So I'd like to note 2 points, however. I apologize because each time when I speak in this kind of press event, I do not necessarily speak of the symbolic aspect of things, but I'm speaking about the legal aspects because I'm a lawyer, and this is why I defended Mr. KHIEU SAMPHAN. So from a legal standpoint, there are two things that really impacted me, that surprised me. The first is the interpretation of legality by the Supreme Court chamber, and I'm really waiting impatiently to know what are the grounds for their decision regarding a certain number of points, whether it be forced marriages, whether it be the issue of certain other crimes for which we explained that the law during the times of the facts is not the same legislation that can be applied today. So I'd like to understand the Chamber's reasoning behind this. And the second point that surprised me, and that even as a simple lawyer, not simply as a defense lawyer, but as a jurist working before several international courts, I must say that the question of murder with dolus ventralis and what the chamber decided regarding joint criminal enterprise, which is the mode of responsibility that was retained to affirm KHIEU SAMPHAN's guilt. Well, this is a point that maybe for people in the audience might be difficult to understand. But basically speaking, the Supreme Court chamber took a stance that it stood by up until today. But when we went before the trial chamber the second time, the trial chamber judges decided not to follow the position of the Supreme Court chamber. And today, whereas none of the parties, that is neither the prosecutor nor the defense lawyers, nobody had raised this issue regarding joint criminal enterprise and murder through dolus ventralis, the chamber has seized itself propria muto, and I find that a bit of a pity in terms of legacy of the ECCC, that this will be what remains. That is to say that we have interpreted in a rather special way, in a rather anachronistic way, law regarding this issue, but the future will tell what the legal experts will be able to say regarding this question. But really, this is really something that really impacted me this morning as a jurist. So I apologize if my explanations might be a bit woolly, but these are 2 points that I wanted to put forward. Thank you.
Thank you, Ms. Antakise and Mr. Kongsamon, for your statement. The floor is now open. Mr. Poikia. Yes, my question is this. After the conclusion of the proceeding this morning, did you meet with your client? And if so, did he say anything or wish to convey anything to the press? Second, Mr. Kongsamon said that this judgment is not yet final. So let me go back to Mr. Petra, the spokesperson. What would be the contentious issue? Is it final or not final? For me, I don't have any further comment to what has already been announced by the Supreme Court chamber. Allow me to explain a little bit. There are two issues here. One part is that the judgment is final, but when we listen to the pronouncement of the judgment this morning, it is not yet final. I don't know what other words I can use to say, but in the pronouncement by the President of the Supreme Court this morning, he said that it is not yet full. It means that it does not have an effect for the enforcement. This is my understanding. And he did not only say it once, but he said it on several occasions. And probably this is true because Mr. KHIEU SAMPHAN cannot be transferred to a national prison yet because the judgment here is not yet final. If the judgment is final, it means that this court will need to close down. But if the judges are still continuing writing the judgment, it means that the court is still functioning. That's why I said that this judgment shall not be pronounced when it is not yet final. If it is final and full, it means that when you do the pronouncement, it means that the end of it. That is all. Thank you. And yes, he actually told us something, but I am not here to say anything yet. Thank you, Mr. KHIEU SAMPHAN. Any other questions? No?
Un point pour ajouter. Le jugement est définitif. L'arrêt d'appel est définitif. Maintenant, il n'est pas entier.
The judgment is definite, but it's not entirely reasoned. It is not entirely reasoned, and Mr. KHIEU SAMPHAN cannot be transferred as long as the judgment has been entirely reasoned.
Voilà, mais le jugement est...
The judgment is definite in the sense that it's the last recourse, and therefore the chamber decided to affirm the trial chamber judgment. So legally speaking, this is definite. Now, of course, the judgment has to be reasoned in its totality, and that's what's missing.
I said the judgment is final. It's only the motivation that is missing. We only had a summary of the judgment, but we will have, at the end of the day, we are waiting, as they say in due course, we will have the full reasoning of the judges, and that's what we are waiting for. So in terms of the comments that we can have, as I said, as long as we don't have the motivation on all the arguments of the Supreme Court chamber, it's difficult to comment. We just have an idea because of the summary, but the full reasoning of several pages will come in due course. And in the meantime, Mr. KHIEU SAMPHAN will stay on the premises of ECCC until the judgment is delivered in a written form with all the reasoning of the judges. I hope it's clear.
Thank you. Any other question? My name is Kamsun from Khmer Time. Regarding the health of your client, how is his health? Does he have like chronic diseases during his final stage? Thank you. This is a final question.
Well, we are not authorized to give you very precise information about the state of health of our client. Well, we're all human beings here, and we know that a person who is 90, who has more than 90, has the health problems of a person who's more than 90. You saw the evolution of Mr. KHIEU SAMPHAN before this court. He arrived at the first, he was walking in the first years, and today he left in a wheelchair. So this gives you some idea of what his health is like. He is a gentleman of more than 90 who has the problems that are normal for his age.
Regarding the state of health of Mr. KHIEU SAMPHAN, it is a sensitive issue for this court. For that reason, they need to expedite the pronouncement of the judgment. We understand that health is a personal issue, so it cannot be discussed here in public. But visually, you can see his state of health when he entered the courtroom. So you can make your own observation. And second, regarding his age. And on average, he actually is he lives much better than some other people. He is now 91 years old, so it's a very, very advanced age at the moment for him. Thank you to Mr. Kong Sam-on and Ms. Antakise for joining our press conference after the pronouncement of the final judgment against the appeal. And I wish both of you good health. And allow me to close this portion of the press conference for the defense of Mr. KHIEU SAMPHAN. And we have another team that is the lead co-lawyers for civil parties. Thank you. I'd like to invite the lead co-lawyers for civil parties, please.
Còn làm ở đây. សូមជូនសហមេធាវីកំពុងតែធ្វើដំណើរមកបាទសូម
The lead co-lawyers for civil parties are on the way, so please bear with us for a moment. I think we will have lunch after 2. Now let we continue our press conference, the final portion of the press conference with the lead co-lawyers for civil parties. Now we have Mr. Pich Ong with us, and his counterpart will be here. So let me start now. Good afternoon to everyone who is present here in and around the courtroom. Today we have heard the pronouncement of the final judgment by the Supreme Court chamber in the courts of Cambodia. For our lead co-lawyers for civil parties, we welcomed this pronouncement of the final judgment. So this is a definite judgment. It is definite because there is no further changes to the judgment. Although the judgment is not fully reasoned at the moment, but from what we have heard, the statement by the president of the chamber, a complete version is being translated. So this is a final judgment. And later, when the judgment is the fully reasoned judgment is translated and published, it means that it's going to have an effect for the enforcement. So it means that it is final, it is definite, and there is no further appeal available. So when it is translated into the 3 official languages of the court, then it means that it will have an effect for the enforcement. For us as lead co-lawyers for civil parties, we are happy to receive the judgment as pronounced by the court this morning. And we have observed the good points in laws and in facts as analyzed and found by the Supreme Court chamber in relation to the form or responsibility of Mr. KHIEU SAMPHAN, as well as on the responsibility for other actions, including the third form of JCE, as well as the finding that male victims are also subject to sexual violence as part of the crimes against humanity. And that is a good point that we found. Also, we hear a comprehensive analysis of the facts in the case. So, for us, representing the collective group of civil parties, we are of the view that the pronouncement of the judgment this morning is a historical moment for our civil parties, who have been waiting for over 10 years for this kind of judgment. And indeed, some of the civil parties have passed away in hundreds, although we don't have an exact figure for that. And we still have surviving civil parties who are still with us and who actually ask us every time we meet with them on the proceedings here at the court, and when it's going to be concluded and what will be the end result. So they are still interested in the court's work. For that reason, the pronouncement of the final judgment is a testimony to the fact that the civil parties are happy with the process, and they are happy that people who are found responsible for those crimes are convicted, so then they can put your mind to rest regarding the work here at the ECC, and they can focus on the work they do for their livelihood and to live with their families in the society. So, as I said earlier, the pronouncement of the judgment puts their mind at peace, and they won't feel any grudges against other former people living in the same community, or tries to find way to ensure that such crimes would not happen again. We also have various reparation schemes for civil parties, so that there is an intergenerational dialogue between the old and the new and the young generation, so that they can ensure that no such crime can happen again in the future. This is how they participate in the court proceeding, narrate their stories or events that happened, and ensure that no such crimes would happen in the future. And my colleague, Ms. Faguni, may have something to say as well. So the floor is yours.
Thank you so much, Ang. So, as my colleague has said, on behalf of the civil parties, we welcome this final judgment of the Supreme Court chamber in case 002. I believe it will take some time to absorb the enormity of this judgment. It recognizes and puts into the record what happened here between 1975 and 1979. It recognizes the stories that the civil parties told during case 002, and it firmly establishes this story in Cambodian history. It's also a significant judgment for the international community because KHIEU SAMPHAN, as the chairman of the State Presidium, was the head of state, and he has been held accountable for the untold misery visited upon Cambodians over a period of less than 4 years. We recognize that with the conclusion of the judicial portion of this case, there is more work to be done, and indeed, as we have heard from various groups, including the government of Cambodia and the international community, we look forward to continuing to work with the civil parties and the victims during the residual mechanism over the next 3 years. Thank you.
Thank you. I think we also have some journalists who actually are in another room, but I think that we have listened to the statements made by both lead co-lawyers for civil parties regarding their understanding and impression of the judgment, as well as the position of the civil parties. And I'd like to thank all parties for attending the press conference today, and I'd like to thank the national and international journalists as well. We all know that the pronouncement or the final judgment in case 002/02 is a final judgment of this court. And in accordance with the work plan of this court, the court will conclude its judicial activity by the end of 2022. And starting from 2023 to 2025, that is a 3-year period, they will continue to work on the residual functions of the court. Deputy Prime Minister Bunchen stated this morning during the press conference as well. So again, I'd like to thank all of you, and I'd like to say goodbye and wish all of you as well as the audience who follow the proceedings all the best, good health. And actually, Mr. Pik Ong would like to have a final word before I conclude our press conference session. Thank you. Regarding those who committed serious crimes, of course, they would be subject to prosecution regardless of their status or advanced age, as in the case of KHIEU SAMPHAN, Nuon Chea, and Ieng Sari. As long as they are fit for trial, they would be prosecuted. So for anyone else, they would not evade the justice of the court. And also sometimes, even if part of the law may not be applicable for the prosecution of his activities, of course they would find solutions, that is legal solutions on other laws that can be used as a basis for the prosecution of their criminal activities. So this court proceeding is a testimony that finding justice is important for the victims. And there is no impunity for those who committed such criminal acts. And I hope that leaders in other countries in the world would understand about the consequences of this court, so that they would not commit any serious crimes or lead to such a tragedy happen again in the future. Thank you, and thank you, Mr. Pik Ong and Ms. Phagani, for joining our press conference. That is for the last segment of the press conference. This is the final moment that we are here in this court after the 16 years. And probably this is the final moment, and it's not going to happen again. So we will remember this historical day, and this is another achievement added to the milestones achieved by this court. I'd like to thank everyone, and also I'd like to thank interpreters who are here, still here with us till the final moment, although it is now 2 p.m., who tries to work very hard. And also I'd like to thank the journalists who are here and who are in another room doing their work. So here we are contributing to the testimony of another historical event for the final judgment of this court, which is a mixed tribunal between the Cambodian government as well as the UN to prosecute crimes committed during the Khmer Rouge regime. I'd like now to close the press conference. Thank you. And thank you for the pronouncement of this court for the victims. Thank you.